Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and address for the record.
My name is Swain, and I am currently held at the Ohio State Penitentiary in Youngstown, Ohio.
You are the plaintiff in Swain versus Annette Chambers Smith, Franklin County case number 24 CV 7806.
Yes.
You are the plaintiff in Swain versus Ohio Adult Parole Board, Franklin County case number 24 CV 6304.
Yes.
And you consent to this sworn video testimony to be turned over to your counsel, Eric Allen, for his use in either or both of those cases.
I do.
And you understand that you are under oath, and this testimony may be shared with opposing counsel and with the court.
I do. Yes.
Can you briefly describe the civil action against Annette Chambers Smith?
Yes. The case against Annette Chambers Smith originates from my out-of-state transport to the state of Virginia in 2019, which is in contravention of the Ohio Constitution. And the intended transport that occurred in February of 2022 and resulted in me losing my finger. And the fact that that transport has not been, has only been postponed while the case pens.
Okay. Can you briefly describe the civil action against the parole board?
Yes. I saw the Adult Parole Authority in August of 2021, and during the course of that hearing, they relied upon erroneous information. They relied upon disciplinary findings that were part of a weaponized process. They relied upon protected speech in a public forum, and they relied upon public opinion as their basis for turning down my parole and extending me for 5 more years.
Should we start with some background?
Sure, yes.
You graduated high school?
Anchor Bay High School in Baltimore, Michigan.
You entered the military?
U.S. Army in 1987.
After
2-year enlistment. Yes.
After the military?
Discharge.
You went to college after the military?
Yes, I attended Bowling Green State University, their Firelands campus in Huron.
You received a scholarship?
Yeah, a writing scholarship from the Ruttinger Foundation.
Prior to the case for which you are now in prison, did you have any prior criminal record?
No. In fact, I didn't even have a record of traffic tickets.
Can you describe the circumstances that led to your current imprisonment?
Yes. In 1990, I met Diane Shio. This is in Sandusky, Ohio, and we began dating. She had 2 children. The younger of her kids was fathered by Andrew Crouch in a prior relationship. We moved in together in January of 1991, and in April 20th of 1991, after a custody dispute, an argument over the phone between Andrew Crouch and Diane, Andrew Crouch kicked in the apartment door when I was alone in the apartment. He said he was going to find me and kill me, and in a panic, I stabbed him and killed him. I stabbed him 5 times. Stabbed him and killed him, and I called 911. And so, yeah, he died about an hour later.
Did you claim self-defense at the trial?
I did, yes.
This, as in 1991, before Ohio adopted the Castle Doctrine?
That's correct, yes.
Did you take a polygraph prior to trial?
I did.
Did you pass?
I did.
Was the polygraph admissible?
No. The prosecutor in the case, um, I had taken a stipulated polygraph test, and so once I passed that, my counsel attempted to get the prosecutor to sign off on an unstipulated polygraph that would be admissible. And because the prosecutor knew I had taken the first polygraph, he wasn't about to sign off on the second one because he realized that meant I had passed it. So it wasn't admissible.
What was the result of your trial?
I was found guilty of aggravated murder and murder, and then a null prosequi was entered on the charge of murder, and I was sentenced on the charge of aggravated murder, 20 to life.
Did you appeal?
I did.
What happened on the appeal?
The Court of Appeals found that my right to compulsory process was violated because my experts weren't permitted to testify based upon a local rule. So the Court of Appeals then told the trial court, when it was remanded, to allow the testimony to be heard because the prosecution had waived all other objections. So I went back for a retrial.
When the case returned to the trial court, what happened?
The trial court judge did exactly what she was told not to do. She entertained objections under the rules of evidence and excluded most, but not all, of the expert testimony.
You went back to trial then?
Yes.
You were again convicted?
Yes.
What was your sentence?
20 to life.
So after a trial, an appeal, a retrial, and an appeal, the judge sentenced you to the minimum sentence she could give you.
That's right. Yes, and I was the most expensive case in Erie County history at the time.
And you appealed?
I did.
What was the result of the appeal after retrial?
The appeals court judge that wrote the initial opinion was taken off of the appellate panel and was replaced by another judge who was not familiar with the case. That judge wrote the opinion post retrial and said that the trial court was not wrong for essentially ignoring the previous appellate ruling. Said that that the clean slate doctrine applied. So this is the only case in Ohio history where the law of the case doctrine did not apply, and the clean slate doctrine did. And by the way, there is no such thing as a clean slate doctrine. It was only used in my case.
Have you suggested that there was a political component to your case?
Yes, I have.
Can you explain how you draw that conclusion?
Yes. So the judge and the prosecutor in my case both belonged to the same political party, as Colette Crouch was the chair. So Colette Crouch was the aunt of the decedent in my case. She was the chair of that political party, and so the judge and the prosecutor both required her approval for them to continue their careers, come election day. There was a great deal that occurred in the case that was very anomalous.
So you do suggest that there was political influence applied in your case?
Yes, I do.
Was there evidence concealed in your case?
There was, yes, including break-in photos that the police claimed they never had.
Was there false evidence presented?
Yes, including the coroner's testimony. At the first trial, she testified that I stabbed Andrew Crouch from behind. But after we got our own coroner to review the evidence and debunked her story, she changed her entire testimony in the second trial and claimed that he was in fact stabbed from the front.
Has the integrity of the prosecutor been called into question?
Yes. There's a website about him that was put together by his family. His name is Kevin Baxter, and the website is theexposer.com. It's the-exposer.com, and the entire website is dedicated to his corruption in several cases. And my case is also presented there.
Do you consider yourself a non-criminal?
I do, yes.
Can you explain it?
Yes. So I didn't do anything that violated the law. Andrew Crouch is dead, but I didn't do anything that violated the law. And I know what happened on April 20th. So I know who I was, and I know what my intentions were. And so based on that, knowing who I am, I don't define myself by what the trial court says I am. I realize I'm a convicted felon. I don't deny that. But I deny that I'm a criminal, because I'm not.
So this position you've taken regarding the process, does this mean you're not sorry about the death of Andrew Crouch, or that you don't take responsibility for your actions?
No, not at all. So the question of whether or not I committed a crime is a legal question, and the question of whether I feel remorse is a human question. And I have to live every day knowing that Andrew Crouch's parents had to bury their son. And I have to live with my role in what happened there. And I take full responsibility for the actions that I undertook and for the decisions that I made that led up to that, because I shouldn't have been involved with Diane. I shouldn't have even been in that relationship. It wasn't going anywhere. We weren't serious. It was a relationship of convenience. And I thought I knew everything. And I thought I could handle whatever was happening. And I thought I had everything under control right up until I didn't. And so, yeah, I have to live with all of that. But I can only own what it is that I actually did. You know, I killed Andrew Crouch. I didn't murder Andrew Crouch, but I did kill Andrew Crouch, and I have to live with that. I knew his sister. I worked with his sister at Kroger. I didn't know she was related to Andy. I didn't know, but at the time that I worked at Kroger, I was a bag boy, and I would go to the deli and change the garbage there because Molly was pregnant, and I didn't want her to have to live there. And I didn't realize until after Andrew Crouch had died, well, she is his sister, and I know her. And so I have to live with the fact that I actually know somebody that loved him and misses him on the holidays. So, yes, I feel remorse. I'm not a criminal, but I do feel remorse. Those are two separate questions.
Okay. Are we able to talk about prison right now?
Okay, yes.
Have you been in prison continually since 1991?
Yes.
Have you developed a philosophy or an approach to how you conduct yourself during your incarceration?
Yes, I have. I decided early on that I'm going to be who I am, and that prison is a question of geography. There's a fence, and I'm on one side of it, and the vast majority of the human race is on the other side of it. But that doesn't separate me from the rest of the world. And I can still engage the rest of the world, and I can still make an impact on the world. And I think we all have an obligation to do that to the extent that we can from wherever we are. And so that's always been my approach.
Have you joined civic organizations?
Yes, I have.
Can you list a few of those?
Yes, I joined the American Civil Liberties Union. I joined the International Campaign for Tibet. I joined Pax Christi USA, which is a Catholic peace group. I joined Cure Ohio, which is the Citizens United for the Rehabilitation of Errants. And I was a founding member of a group called Catholic Justice Fellowship, among other things, but those groups.
Exhibit 3, were you a member of the Prisoner Advisory Board for Cure Ohio?
Yes, I was for about 3 years.
Can you talk a bit about Catholic Justice Fellowship?
Yes. So in the mid 1990s, I got together with another prisoner named Ola Sharin, and we started the group Catholic Justice Fellowship. It was out of the Diocese of Toledo. Deacon Russ Shoemaker was our facilitator, and we would meet, and our our purpose was to generate information about the systems of justice and corrections, uh, and apply Catholic social justice teaching to what it's supposed to be, and then we would send that information to the Catholic bishops in Ohio, in order to get them to support prison and justice reform. And we were successful in doing that. The Ohio Catholic Conference assigned a policy advisor named Jim Tobin, who testified in favor of parole reform legislation before the Ohio Senate, when that legislation was pending. So, we had some success lobbying the Catholic bishops.
Good. Exhibits 4 through 6, you have correspondence from a bishop and an archbishop relating to your social justice work in prison.
Yes.
Tell me about the Victims of Crime program.
So, the Victims of Crime program was organized by Prosecutor James Mayer Jr. in Richland County, who got together with Fran Porter, who was an administrator at Mansfield Correctional when I was there. And what they wanted to do was get prisoners at Mansfield involved in support for victims of crime, particularly kids. So we prisoners built the sets and stages, wrote the screenplay for puppet shows, sewed the puppets, and I was put in charge of getting prisoners together who were musicians in order to record the soundtrack that would play behind that. And so they recorded the puppet shows, and they would play them for children who were hospitalized as victims of crime. And the cool thing was they didn't have to do this, but they did it. They took video of the kids watching the puppet show and let us see that video. So that was rewarding.
Yes. Exhibit 7 and 8, Richland County Prosecutor James Mayer Jr. commended you for your work in that program.
Yes.
Did you volunteer to do any community service work while you were in prison?
Yes, I was assigned to the community service program for about 2 years.
Okay. How many hours of community service have you logged?
Oh, geez, a few thousand. I worked 35 hours a week for 2 years. I was a painter. I did the visual aids for the Mansfield City Schools.
Exhibit 9 is an evaluation where you received a perfect score as a community service volunteer.
Yes.
Exhibit 10, Rosa Parks nominated you in 2002 for placement on the Wall of Tolerance for your peace work in prison.
Yes. Yeah, she was a hero. And so that meant a lot.
I'm sorry.
Yeah. Oh, go ahead.
What was the Breaking the Cycle program?
So Breaking the Cycle, the full title was Breaking the Cycle of Crime, Violence, and Imprisonment. And that was developed, I worked on that with Khalil Osiris, who was locked up at Mansfield with me. He had a master's degree in education, and I had my degree in the social sciences. So we decided to start a program that would be a mentorship program, so that the first, are you still there?
Yes.
Okay, I thought you froze.
No.
I'm sorry. So don't edit that out. But I'm just going to look dumb. So Um, we developed that to be a mentorship program so that the first group that would go through it, we would train them to be facilitators, and then each of them would start their own groups and so on. And so it would work as a kind of pyramid scheme. And we first applied it at the mental health unit at Mansfield. It was run by Luann Bay, and she let us do a pilot program there. And those were guys who had like serious mental health struggles. So the guys who went through our program, um, she noted marked changes in they were cleaning their cells, they were engaging in personal hygiene, they were prompt and on time for other programs and other sessions that they had to be part of. And so there was an improvement in their pro-social um, behavior as a consequence of going through that program. So, um, so yeah, that was rewarding.
The co-creator of that program, can you talk a bit about him, what he has done since you developed Breaking the Cycle?
Yes. So Khalil Osiris was the co-creator, and after a successful cycle of that program, he was labeled a gang leader for having developed it, and was tossed in the hole at Lucasville. He got out of prison, and he now develops programs that the ODRC employs, and he was hired as a consultant to the nation of South Africa
Okay.
to overhaul their entire prison system.
Okay.
So that's what he does.
Okay. Have you pursued education in prison?
I have, yes.
Have you earned a degree from Ashland University
Yes, in the social sciences.
with honors
Yes,
and 2 vocational trades?
yes. That's all they'll allow me to take is two. So I've taken the limit.
You have a paralegal certification?
Yes, I had to pay for that myself um, because I couldn't take that through the prison system.
Have you taken rehabilitative programs?
Yes, I have. I've taken every rehabilitative program that's available to me at the prisons where I've been held.
And focus?
Yes,
Thinking for a change?
yes,
Life skills?
yes,
Current events?
yes,
Wilmington College Book Club?
yes,
Those certificates are exhibits 12 through 17.
yes. That's right.
You have 3 books in publication?
I do. Yes,
Can you talk a little bit about those?
yes. So the first book was called Last Act of the Circus Animals. It's a work of fiction, and I co-wrote that with another prisoner named Travis Washington. And it's about talking animals in the circus who are discussing the nature of the circus and its exploitation of the animals and what they should do about it to liberate themselves. That's the first one. The second book is called Ohio, and it gives a kind of historical background on the so-called founding of Ohio, which was invasion, colonization, and genocide. And so I call into question and try to deconstruct the cultural approaches that we have to understanding the legitimacy of our systems. That's Ohio. And the third book is called Opposing Torture, which is a memoir about events that we're probably going to talk about later in the deposition, um, where I was subjected to a domestic torture program, and how I attempted to expose it, and how my exposure of that domestic torture program drew the ire of prison officials who didn't like the fact that I was exposing it. So, yeah, those are those three.
You have contributed to other books as well.
Yes. There are two books that came out by Save the Kids that I contributed to, including one called Why America Why, and I also contributed a segment to a book called Rattling the Cages, Oral Histories of North American Political Prisoners. That was put together by a friend of mine named Josh Davidson and another prisoner uh, that he was in support of, Eric. And, um, and that came out through AK Press.
And you have a fourth book coming out soon?
Yes. Right now I'm between publishers. Josh Davidson, who came out with Rattling the Cages, who compiled that, is looking to get me a publishing deal for a fourth book, and he's trying to get me the most money possible. So I don't know who the publisher is yet, but it's tentatively called Liberated Territory, and it's that title is taken from a quote by Abby Hoffman, who said, he said, "The ground you're standing on is liberated territory. Defend it." So the title of the book is Liberated Territory. It contains all of my public statements from conferences and symposia, and all that stuff. So yeah.
Can you talk a little about the portraits that you donated?
Yes. So I still paint, even though I'm not part of the community service program. They shut that down. But a friend of mine, he works at the radio station where I do the radio show, and he had a friend of his who was a Russian national who had immigrated to Ukraine, and had when Russia invaded Ukraine, he, along with a bunch of others who were civilians, set up a kind of volunteer brigade to defend the Ukrainian citizens against that invasion. Um, and he died. And two Americans who were former military also were volunteers in that brigade, and they died as well. And so the friend of mine commissioned me to do their portraits. So um, I did two copies of each portrait of each of the three men, and one was given to their families, and the other one was auctioned in order to raise funds to support them.
Exhibits 18 through 23 are portraits you painted and the photos you worked from.
Yes.
Have you had other opportunities to showcase your art?
Yes, there was an exhibition of my art that took place in Stockholm, Sweden. I'm sorry, it sounds funny coming out of my face, but yeah, my art was showcased there. Yeah.
That's exhibit 24 is a photo of the art exhibit being prepared in Stockholm, Sweden.
Yes.
You also contribute radio commentary?
I do. Yes.
Can you describe that process?
Yes. So I will call in to the radio show usually on Tuesdays, and record my commentary, and it airs on Sundays in Asheville, North Carolina, the Final Straw Radio Show. After it airs on Sundays, it's then distributed to subscribing radio stations around the world. It's globally syndicated. So over the course of that following week, it gets played over the radio in all of those locations. And then my understanding is that it's then posted to the radio show's website, and it's also posted at what's called the Channel Zero Network. I'm not sure how that works, but yeah.
How long have you contributed to the Final Straw radio show?
It's over 10 years now.
Do you have a relationship with the University of Michigan?
Yes, they collect my personal papers and effects for an archive to celebrate my influence over American culture. I'm sorry, it just sounds so weird, but yes.
Let's turn to your disciplinary history.
Yes.
How many times have you been accused of acts of violence in 34 years of imprisonment?
Never. Not one time.
How many time for drugs?
None. Zero.
Alcohol?
Zero.
Are you now or have you ever been a gang member?
No. In fact, to quote Groucho Marx, I would never be part of any organization that was so desperate as to have someone like me for a member.
So tell me if I have this right. You were sentenced to 20 years to life for an act of self defense. You've served more than 34 years. You've been active in social justice and civic organizations. You've
Yes.
completed thousands of hours of community service voluntarily, taken
Yes.
all available programs,
Yes.
earned a college degree, a,
Yes.
a paralegal certification.
Mhm.
You've published 3 books,
Yes.
contributed radio commentaries for over a decade,
Yes.
had your art exhibited internationally
Mhm.
without so much as an accusation of violence, drugs, or alcohol. And the Ohio
Yes.
prison system's response has been what?
Um, I have been elevated to Supermax 3 times. Um, I have been black-sided. I have been illegally renditioned. Um, I have been subjected to an attempted second rendition where where I lost my finger. Um, and I've been subjected to a year of torture.
Okay. Let's turn now to ODRC counsel Trevor Clark. You have
Okay.
alleged that Trevor Clark weaponized the disciplinary process and engaged in invidious retaliation in order to justify your interstate transfer to Virginia and to also influence your parole suitability determinations. Is that right?
Yes. Yes.
So, first, in your experience of 34 years of imprisonment, how often do Ohio prisoners normally encounter legal counsel for the Department of Corrections?
Oh, almost never. I don't know of any other prisoner who's currently locked up who's ever had um, a one-on-one personal encounter with anybody working with ODRC Legal Services.
Okay. But you have had multiple encounters with ODRC counsel Trevor Clark.
Yes, yes. By my count, one, two, three times.
Okay. How did you first come to know Trevor Clark?
Okay, so this would have been in 2008, and I was at Toledo Correctional, and uh, the FBI had raided a safe house for a group called the Earth Liberation Front, which is considered an eco-terrorist group. I don't know a whole lot about them, but they found personal writings of a guy named Daniel McGowan, as I understand it. He was a federal prisoner, and they found a copy of Last Act of the Circus Animals in the possession of one of those people. So FBI contacted the Ohio prison system. The Ohio prison system contacted Toledo, and they whisked me off to the hole. And they put crime tape. I was my cell door in the hole. They put crime tape over my cell door and told the staff they weren't even allowed to talk to me. They went to my cell in population and took out all of the fixtures, including the toilet, the sink, the bed, and they put them through what's called a fluoroscope to X-ray them to make sure there wasn't bomb materials. It was over the top, and so yeah. Um, yeah, that was the incident where where I came to know who Trevor Clark was. Trevor Clark, it turns out, was the FBI agency liaison.
So suspects investigated by the FBI have read your book.
Yes.
You hadn't sent them the book. You hadn't sent the book to them?
No, I didn't know them.
You didn't know them personally.
No,
You had no relationship with them.
none.
So did the FBI conclude that you had no relationship, no nexus?
Yeah, that's my understanding. I was released from segregation without any kind of thing where with them. So yeah,
And it was after these events you had your first encounter with Trevor Clark.
yes. So after I was released back into population, it was shortly after that I was called to a conference room, a staff conference room, and that's where I first met Trevor Clark. He interrogated me. He was asking me about my ideology and asking me how I feel about government. Um, Full disclosure, I was in handcuffs and chains and shackles. And when he asked me how I felt about government, I said, "Yeah, government's fantastic," and stared down at the chains. So yeah, that was snarky. Um, so Clark told me that I might have the FBI fooled, but I didn't have him fooled, which indicated to me that he felt that I was some, you know, nefarious super terrorist trying to take over the world.
What was your impression of Trevor Clark?
Um, he seemed aggressive. He seemed pushy. He seemed like one of those guys who knows everything. And frankly, I hate bullies, and he seemed like a bully. And so I have to imagine that, I probably wasn't very good at hiding um, my personal disdain for him.
Did you have a sense of how he felt about you?
Yes.
And
Um, I didn't get the sense that he'd be asking me to the prom anytime soon.
okay. What have you learned about Trevor Clark since that encounter that influences your conclusions about him?
So, first, there were some disclosures in federal court when Richard Kerger attempted to file a civil action for me. And in those disclosures, I learned that Trevor Clark is the agency liaison for the FBI, and he's the agency liaison for the Ohio State Highway Patrol. And so he is the conduit through which all of those law enforcement agencies communicate with the ODRC. So anything to and from the ODRC goes through him.
Okay.
That's the first thing that I learned.
Anything else?
Um, Through the Freedom of Information Act, um, I received pieces and parts of my FBI file. Um, and I noted that the ODRC continued sending information to the FBI about me. Um, and the FBI reports seem to continually debunk um, what the ODRC was sending, um, and continually found the information to be inactionable.
According to Freedom of Information, what is the length of your FBI file?
It's slightly longer than 4,000 pages.
Have you ever been criminally charged relating to any of those FBI files?
No,
Has the FBI ever interviewed you personally?
no.
And why do you conclude that it was Trevor Clark responsible for transmitting the volume of inactionable material to the FBI?
Well, first, because he was the FBI agency liaison, according to disclosures in federal court, which means he's the one person who is interacting as a conduit between the ODRC and the FBI. And he also said that I had the FBI fooled, but I didn't have him fooled. So it stands to reason to me that he's the one who's attempting to get the FBI unfooled. And I also had the distinct impression that he wanted to be part of the FBI. And so that would easily make me a meal ticket for him.
Okay, we fast forward to 2011, Mansfield Correctional. Did Trevor
Okay.
Clark's name come up again?
Yes. So I had been at Mansfield probably a year and a half, and I was called up to the mail room by a lieutenant who was just on the verge of retiring. And he asked me why all of my outgoing mail would have to go to central office to a guy named Trevor Clark. And I said, well, I don't know. I suspect he wasn't supposed to tell me that central office had given the order to him, but he did. And so I knew that Trevor Clark at central office was going through all of my outgoing mail and opening it.
Do you know what this investigation was a response to?
Friends of mine had just started a website called SeanSwain.org that posted all of my writings there. And I think it's more than coincidental that it was right after that came into existence, and I was writing. It's journalism, and I'm writing pieces that are critical of the Ohio Department of Rehabilitation and Correction. And then shortly after that, something very irregular happens, like an attorney at central office is now reading all of my outgoing mail. That's the conclusion I drew.
Your writings were published online, and so Trevor Clark was secretly investigating you?
That's my understanding, yes. And he was also sharing all of that information with the FBI.
Do you know any other prisoners subjected to investigation by ODRC legal counsel for getting material published?
No, no, I do not.
Okay. A year later, August 2012, can you tell me about the Army of the 12 Monkeys?
Yes. So this was August, September of 2012. There was a group that called themselves the Army of the 12 Monkeys that distributed all kinds of literature all over Mansfield Correctional. They were advocating a campaign of sabotage, and the literature was decidedly Maoist. And I know this because I've read quotations by Mao Zedong, and one of the pamphlets that they put out was called "Painted Black," and all of the quotes were plagiarized directly from Mao's book. Mao has this whole collection of quotes. It's like, things like "the donkey plows the field for the good of the people" and all kinds of other nonsense. And that's what this book was filled with. That's what this literature was filled with. So they were Maoists. I later learned, I didn't know it at the time, but a group called the Maoist Internationalist Movement, I think out of San Francisco, it's out of the Bay Area, was kicked out of the Ohio prison system. They were banned, all of their literature. They were no longer allowed to send mailings to Ohio prisoners. And it was shortly after that ban came into place that all of this Maoist literature was floating all over the compound, and a group was advocating sabotage against the prison system. This all seems very Maoist to me.
And you said they were Maoists.
Yeah.
Oh, you froze.
Yes.
Okay, there you are. Are you a Maoist?
No. No, I can't stand Maoists.
So you didn't share the 12 Monkeys ideology?
No, not at all. No.
Did they find the prisoner responsible?
Yes. His name was Leslie Dillon, and they raided his cell, and they found all of the originals of all of the materials that were floating on the compound. So all of the copies on the compound were copies of the originals that were in his possession.
Did you
And he
know
was about,
Leslie Dillon?
no, no, I did not.
But you were taken out of the prisoner population.
Yes.
Why?
I was told it was on orders from Trevor Clark, um, because I wrote an article that was critical of a new policy. Um, they had just altered a policy so that visitors could no longer send money directly to the prison to be put on prisoners' commissary accounts. It had to go through a third-party corporation called JPay. And I wrote an article that was critical of that policy because the ODRC was then giving personal information of my visitors to an outsourced third-party corporation, and I don't know that I want them having my parents' social security numbers, for instance. And so I wrote an article that was critical of that. So the order was to segregate me as the leader of the Army of the 12 Monkeys because I wrote an article that was critical of the prison system, and that made me the leader of the Army of the 12 Monkeys.
Okay. Can you explain more of that?
Yes. So, because I wrote an article that was critical of the ODRC, and because the Army of the 12 Monkeys didn't share my idea, that made me the leader of the Army of the 12 Monkeys. I'm not making this up. That was their argument. I don't. I think we now know why Trevor Clark isn't a practicing attorney out in private practice. I'm sorry.
Were you ever accused of possessing their literature?
No,
Were you accused of associating with known members?
no,
Were you accused of participating in 12 Monkey sponsored sabotage?
no,
Were you accused of copying or distributing or writing their materials?
no. As a matter of fact, in all four counts of that, Angela Hunsinger, who was the investigator, expressly said that I wasn't involved in any of that.
But you were their leader.
Yes, terrible leadership, it appears. I don't, yes, but I wasn't. But that was the argument, yes.
What happened next?
Um, so I was removed from the prison compound, and I was placed on torture cell row behind the medical clinic. Um, torture cell row is what it was called by prisoners and staff alike. There were 3 cells there. The cell that I was placed in didn't have a bed. Um, I wasn't fed for the 3 days that I was there. I wasn't given a shower. I was just in that cell, and it was as cold as a meat locker. You could actually see your breath in the morning. So for that 3 days, in order to stay warm and not get hypothermia, I had to pace for 3 days. So at the end of 3 days, when I left there, I was sleep deprived and hallucinating. Um, I was removed because a friend of mine had come to visit and was rejected, and inquired what was happening, and their responses were really sketchy. So he got with other people who cared about me, and they began phone bombing the prison, constantly calling and asking what was going on with me, and that's what got them to remove me from torture cell row and take me to SEG instead. After 3 days, there were 3 guys. 2 months after I was removed from that cell, 3 guys died in that cell.
By torture.
I wasn't one of them. Well, they died. They were on torture cell row. They were in a cell that was so cold that it was a meat locker, and they died. And I did, um, because I had people who cared enough uh, to make that stop. And so I was taken to segregation. But when I got to segregation, I was put in a cell with a guy named James Jalilia, who was also a suspected 12 Monkey member. And the torture program began there.
By torture, you mean?
Um, yeah, I'm not saying that as hyperbole, and I'm not saying that as euphemism. I mean torture. Um, and the time that I was in the special management unit, I lost 1/3 of my body weight. Um, I went in 215 pounds, and I came out 155. And when I got to OSP, they diagnosed I had thrush on my tongue. I had the ringing in the ears. I was dying of malnutrition. Um, I was subject to sleep deprivation. Um, they had a special program just for our cell that they would come around and rattle the door every 15 minutes, 24 hours a day, in order to make us respond so that we wouldn't be able to get any kind of sleep. Um, they deprived us of soap. They would um, they would cut the bars of soap in half and only give us a half of a bar of soap, which was significant because we also weren't getting laundry. The other cells were getting laundry, we were not. So we had to wash our own clothes, and we only got a half a bar of soap. So they actually had somebody sawing the bars of soap in half. And then when that wasn't good enough, they then halved those halves. So we ended up with quarter bars of soap. And so we stunk for several months at a time. Um, the window in the cell that we were in wasn't attached to the wall. You could actually move the window. The glass window would move in the space it was in. So there was a rush of air that came around that. So in the middle of winter, when there was snow outside, you would look out the window, and there was a half moon of 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 grass right underneath our window because of all the heat that was in the cell the entire winter.
Okay.
Um, our mail was intercepted, even mail from council. Um, we had no phone, no communication with the outside world. We had to find ways to smuggle communication out through other prisoners. So everything we experienced, if you read the Kubart Counterintelligence and Interrogation Manual by the CIA, that is the blueprint of what we experienced for a year. It is what the CIA calls the simple torture situation. It's in the manual itself. And so what the CIA was doing at Abu Ghraib, Trevor Clark was doing to me, and claiming he was doing it on the orders of the FBI.
And Trevor Clark told you this?
Yes. March 27, 2013, I was subjected to an interrogation with Trevor Clark himself. During this interrogation, he had his phone face up on the desk, claiming that the FBI was listening in. And he also had probably hundreds, if not 1,000 pages of my outgoing mail that had been photocopied, and he had it stacked up on the desk. And he let me look at it, and I was flipping through it. It really was my outgoing mail. He told me he had read every page of that.
About your mail. You believe Trevor Clark misinformed the director of the ODRC?
Yes. So I've received emails through public records, and that includes emails of Gary Moore himself, the director, and he sent an email chain to every prison in Ohio discussing me and the potential for terrorism at different prisons because he was informed of information that was in my outgoing mail, which point of fact I know there was no terrorism threats going out in my outgoing mail. I mean, you can think whatever you want about me, but I'm not an idiot. And when I already have been told that my outgoing mail is being searched and logged and cataloged and read, I'm not going to try to do something illegal that I'm going to try to get away with. I'm not that dire.
Did you ever plan crimes or plot terrorism through the mail?
No, never.
Were you ever charged with crimes or terrorism?
No,
Were prison disciplinary charges brought?
no.
And you suspect that it was Trevor Clark who misrepresented the contents of your mail to the director in order to make you look like a terrorist.
Well, he's the only one I know that had hundreds of pages of my mail stacked up on a desk. So, yes,
Was this the interrogation where Trevor Clark engaged in inappropriate sexual conduct?
it is.
Can you describe that?
Yes. So, um, when the interrogation was over, Vinko Kucinek was also in the room. Um, he got up and left the room to go get security staff who would escort me back to my cell. And I was alone in the room with Trevor Clark. Um, this is when he was threatening to bring more disciplinary charges regarding the Army of the 12 Monkeys because that had already been reversed. So he asked me if I wanted those charges to go away, and I said that I did. So he took some paperwork and slid it over to the side of the desk and motioned for me to get up and go look at it. So I stepped over to the side of the desk and I looked at the paperwork. I was wearing handcuffs and shackles and belly chain. So um, I picked up the paperwork and I looked at it and I was confused because it wasn't really about anything at all. And that's when he grabbed my crotch. He had his hand. Um, he put his hand up underneath my crotch and then lifted his hand. Um, it was strange. It's like he was, the same way you might try to weigh a piece of fruit. That's kind of how he was doing. Um, and the guy had huge hands, by the way. Um, and he told me that if I wanted the disciplinary charges to go away, that all I had to do was drop my pants and spin around. And I didn't say I was paralyzed. I was just kind of frozen there for a minute, like did this just happen? I was in disbelief. It isn't that I was either going to submit to his demands or not submit. It's that I really hadn't had time to think about it. And then he just pointed at the chair and I went and sat down. And as I was sitting there, I was thinking, did that just really happen? Did that really? Because he's acting as if nothing had happened at all. And then I was taken back to my cell.
Did you report it?
Oh, absolutely not. No, no. Um, I mean, it was. I didn't even tell Jalilia, who was in the cell with me. I didn't even tell him that it happened. Um, it was just very confusing. It wasn't until about a year later, probably in January of 2014, might have been February of 2014, I had an outgoing email, handwritten email for scanning and sending out. And in that, I mentioned the inappropriate sexual conduct. Um, and that was at OSP in an email.
So you mentioned the sexual misconduct in an outgoing email 10 months later. And what happened?
Uh, within a week, all of my communications were shut down. All of my communications were suspended. I was put on what Trevor Clark called black site in place. That's the term that he would use later.
On whose orders?
Uh, I was told by investigator David Wiley that it was Trevor Clark.
So 10 months after all investigations ended.
Yes.
So 10 months after Trevor Clark engaged in appropriate sexual touching, Trevor Clark was still reading all of your mail and he saw a reference to his sexual misconduct and he ordered all of your communication mediums suspended.
Yes. And he would later use the term black site in place. Yes.
Richard Kerger was your legal counsel at the time.
Yes.
Did he ever inquire about you being black-sided in place?
Yes.
With whom?
He was in correspondence with Chief Counsel Stephen Gray.
And what did Chief Counsel Stephen Gray do?
In May of 2014, he sent correspondence to Kerger and to myself, and he threatened disciplinary charges, communication suspensions, an elevation of my security, and transfer out of state if I didn't drop the Prison Rape Elimination Act complaint against Trevor Clark.
Chief Counsel threatened you with disciplinary charges, communication suspensions, elevated security, and out of state transfer if you didn't drop the Prison Rape Elimination Act complaint against Trevor Clark?
True. Yes.
Did you pursue the PREA complaint?
I did.
Which of the threatened retaliations were carried out?
All of them.
So the PREA retaliations that Chief Counsel Stephen Gray threatened in writing, that he threatened would be imposed if you did not drop the PREA claim against Trevor Clark, were all imposed after you pursued the PREA claim.
Yes. They weaponized the disciplinary process repeatedly in order to create a disciplinary file. They blacksided me in place several times, once for more than a year without notice or explanation. 3 times they sent me to the Supermax, and they transferred me to Virginia. Um, they brought me back from Virginia, and they slated me for transfer to Maryland, and in the botched transfer, they chopped off my finger.
Have you attempted to raise a PREA claim relating to that retaliation?
Yes, I have, several times.
And what was the result of that?
They will not allow me to file the PREA claim.
So when the ODRC investigates an initial PREA claim and determines that claim to be inconclusive, you are banned from raising any subsequent retaliation claims, no matter what the PREA violator does to you in retaliation.
That's correct.
Before we move on to an overview of the prison disciplinary process that you claim was weaponized against you, to sum up what we covered, you were framed as a gang leader, subjected to a clandestine torture program, subjected to improper sexual misconduct, sent to Supermax, black-sided in place, later subjected to illegal rendition out of state, and had your finger chopped off in a second botched rendition. And it all stems from you having written a book about talking animals at the circus.
Yes.
The disciplinary process. We'll move on to talk about the prison disciplinary process, which you claim was weaponized against you, correct?
Yes.
The disciplinary process is governed by the Ohio Administrative Code, which is quasi law in Ohio.
Yes.
For anyone who doesn't know how the disciplinary process works, can you walk us through it?
Certainly. Yes.
Let's start with the charging instrument.
Okay. So, Ohio Administrative Code governs this process. The sections that are relevant to this are sections 5120-9-06, 5120-9-07, and 5120-9-08, and those are all contained in the exhibits. So the charging instrument is governed by 5120-9-06, and it lists all of the inmate rules of conduct And any staff member who sees, witnesses, or becomes aware of a violation of the rules can file what's called a conduct report. The conduct report states the rules that are violated and then gives a narrative of facts to support that violation. That's the first process in the disciplinary process.
Once a conduct report is written, what happens next?
It is forwarded to a hearing officer. Um, in most prisons I've been at, in fact, every prison I've been at, the hearing officer is your unit sergeant. The unit sergeant handles the hearing officer duties. Um, Now, I don't know that that's true in every single Ohio prison, but I would suspect that it is.
The hearing officer has broad discretion as to disposing of a conduct report.
Yes. So the hearing officer will essentially they will hear your side of the story. Um, they will ask you if you want to call witnesses. They will ask you if you want to question the charging official, and depending on what the rule violation is, there are things that are considered minor infractions like contraband and so on. Um, and so uh, uh, 5120-9-07 governs the hearing officer and what their discretion is. And they can either dispose of the conduct report at a hearing officer level by giving you some sort of minor penalty. And they can dismiss the conduct report if it doesn't actually state a real rule violation, or if it doesn't, or they can bind it over to the Rules Infraction Board for a disciplinary hearing. Those are the three things generally.
What kinds of matters does the hearing officer normally dispose of at the hearing officer level? Is that what you just described?
Well, yes, there are um, anything now that doesn't deal with violence or drugs. Typically,
Mhm.
the hearing officer will simply dispose of it themselves. Um, Serious infractions that involve violence and other things will get bound over to the Rules Infraction Board.
Okay. Okay, so if the hearing officer does not dispose of the conduct report, what happens next?
You go to the Rules Infraction Board for an RIB hearing. RIB.
The Rules Infraction Board, or RIB, are the hearings tape recorded? Are they
They are.
recorded?
Yeah, they're recorded.
How many staff members compose the RIB?
Two staff members. There is the RIB chair and the RIB secretary. The chair is a permanent position, usually a lieutenant, and the secretary is usually anybody that he can pull off the street that isn't busy doing something else and who has the training to be on the RIB. So that's a revolving door position, but the chair is usually a set position assigned to that person.
Walk me through the normal hearing process.
Okay, so um, when you enter a hearing room, they will ask you to state your name. They will ask you if you've been served a copy of the conduct report. They will read a copy. They will read their copy of the conduct report. They will provide you an opportunity to present your defense. They will allow you to question witnesses if you have already arranged for those. They will give you an opportunity to question the charging official. Then they will deliberate and they will render their verdict, their decision.
According to Ohio Administrative Code section 5120908, are you provided an opportunity to present a defense?
Yes.
Call relevant witnesses?
Yes.
Question the charging official.
Yes.
When the RIB deliberates and renders then the RIB deliberates and renders a decision.
Yes.
And what is the standard of proof necessary for a finding of guilt?
The standard of proof necessary is some evidence.
When the RIB finds a prisoner guilty, what are the kinds of penalties the RIB can impose?
Oh, there's a wide range of those. Um, Anything from privileges being suspended for a time to a recommended security review and a transfer to higher security.
The RIB can limit privileges like phones or commissary.
Yes,
Order time in restrictive housing or segregation.
yes,
Order restitution.
yes,
Recommend a security review and transfer to higher security.
yes,
Now, before we go further, should we talk a bit about the serious misconduct panel?
yes. Yeah, that's a good idea.
Can you explain what the serious misconduct panel was?
Yes. So for a time, uh, there were two separate mechanisms for handling disciplinary charges. There was the Rules Infraction Board and the Serious Misconduct Panel. That was governed by 5120 9 8.1, which has been repealed since. Um, but this is relevant for 2019, um, which figures into both of these cases. Um, and the serious misconduct panel was kind of it was at the same time as the RIB, and it would have the authority, the exclusive authority to recommend a security review and transfer to higher security. That was taken away from the RIB. So only the serious misconduct panel during its existence could recommend a transfer to higher security.
So, during the time that the SMP existed, it was something of a parallel mechanism to the RIB.
Yes, yes,
And during the period of its existence, before it was discontinued, the SMP had exclusive authority to recommend placement at higher security.
that's right.
And the SMP was discontinued sometime after 2019.
Yes,
And then, after the SMP was discontinued, the RIB again became the exclusive disciplinary mechanism and resumed its authority to recommend placement at higher security.
that's right.
Let's talk about the impact that RIB and SMP findings have on institutional life.
Yes.
How does a guilty finding at RIB impact your security status?
So um, we receive a security review once a year. At one time, all of my security reviews were happening in July. So I would have to go the period from July at my security hearing until the following July without an RIB finding of guilt or an SMP finding. If I did so, then I would be eligible to drop in security when I would go up for my next review. If you suffer an RIB finding in that year period, um, you're going to be continued at the same security level. So if you're attempting to get dropped to medium and get programs, and you're at close security, you have to go a year without an RIB finding. So that's how that impacts security.
How does a guilty finding at RIB impact your ability to enroll and participate in rehabilitative programs?
Well, for instance, where I'm at, where I was at a level 3 prison, close security, I had taken all those. There are programs available at medium security that I could not get access to without going to medium security. And so an RIB finding continues me at close security for another year and stops me from getting to the security level where I can get those programs.
How does a guilty finding at RIB impact your ability to gain parole?
Oh, that's kind of a triple whammy. Um, First, a finding at RIB stops me from getting to lower security, So I'm seeing the parole board at elevated security. That's a knock against me. I'm not getting the programs available at medium security, so that's another knock against me. And I'm a disciplinary problem, so that's a third knock against me. And all three of those things are considered by the parole board when you go up for a parole.
Your transport out of state is now being justified by disciplinary findings, correct?
Yes,
And your denial of parole is being justified in part by disciplinary findings, correct?
yes,
And your denial of parole is being justified in part by your elevated security, which is due to disciplinary findings, correct?
yes,
And your denial of parole is being justified in part by your lack of programs, which is due to disciplinary findings keeping your security elevated, correct?
yes,
And your denial of parole is being justified in part by your transport out of state, which was ostensibly due to disciplinary findings, correct?
yes,
Now you have argued that the prison disciplinary process has been weaponized against you invidiously in order to create the outcomes. Is that right?
yes.
Can you explain briefly what you mean by weaponized?
So, um, what I mean by weaponized is that they are employed in deliberate bad faith. Um, they are used to create a determined outcome that's designed to harm me. It's to keep me elevated. It's to deprive me of a chance for programs and negatively impact my parole. That's what I mean by weaponized.
So is this merely a situation where you are pointing to outcomes you don't like and then attributing motives to those involved in the process?
No, no, not at all. Um, this is a situation where administrators who are involved in the corruption of the disciplinary process have bragged to me that they're doing it and have told me how they're doing it.
And that includes former ODRC counsel Trevor Clark.
It does.
So let's now get into the ways in which the internal prison disciplinary process was weaponized against you invidiously.
Uh-huh.
Based upon your experience and the information provided to you by the prison administrators involved in the disciplinary process, you have concluded that false disciplinary findings were deliberately engineered through the prison disciplinary process.
Yes.
Since you have already described the disciplinary process, can you now walk through how the process was corrupted?
Yes. So um, the same components apply as the normal process. You have the conduct report, the hearing officer, you have the hearing procedure, and there's also mechanisms for um, relying on how the charges are actually written.
Okay, we start with the conduct report.
Mhm. So the charging official, um, typically it's a local official, somebody who witnesses whatever happened. Um, in my case, all of the conduct reports that are determinative to Swain versus the Parole Board and Swain versus Annette Chambers Smith, all of those were written by Trevor Clark and then were outsourced secretly to, well, not so secretly, attempted to be outsourced secretly to a local official who would then sign on as the charging official.
So all of your disciplinary proceedings relevant to pending cases began with conduct reports secretly written by Trevor Clark, the ODRC lawyer against whom you brought a Prison Rape Elimination Act complaint.
Yes.
Would that include all of the disciplinary actions that appear in Defendant's Exhibit B to summary judgment in Swain versus Parole Authority?
Yes. Yes.
And it would include the disciplinary action upon which your illegal rendition to Virginia was also ostensibly justified?
Yes. Yes, it would.
Were there other disciplinary actions for which you don't know that Trevor Clark was involved?
Yes, WCI 182337, which was a disrespect charge. That was resolved at a hearing officer level. And I don't know that it was initiated by Trevor Clark, and I don't know that it wasn't. But nobody involved in that process specifically mentioned his name.
Now let's get into how you know Trevor Clark authored and outsourced the conduct reports.
Okay, yes.
In the case of MANCI 12-07-219, what was Trevor
Uh-huh.
Clark's role?
In that particular case, Trevor Clark um, was there at the hearing. Um, he said on the record that he was a co-charging official, even though Angela Hunsinger was the only one who actually signed on as the charging official. He was there also, he said, as counsel for Angela Hunsinger. She had to have an attorney, while I did not. Um, and he was also the legal consultant to the Rules Infraction Board. And he was also in charge of the disciplinary appeals after the findings. So, in other words, he admitted on the record that he was in charge of all of the phases of that entire disciplinary process that he was bringing against me.
What about other disciplinary actions?
Um, SOCF 15-1327. In that particular case, the hearing officer, who was the unit sergeant, told me that he was contacted by Trevor Clark and told what to do. All of the WCI conduct reports that are listed and are attributed to Lieutenant Kevin Chamberlain. Lieutenant Chamberlain expressly told me in each of those that he was not responsible for writing the conduct reports, that he was simply signing on at the orders of Trevor Clark. In the case of WCI 16-10754, Trevor Clark himself told me prior to the writing of the conduct report that he was writing it. And then after it was written, Kevin Chamberlain told me afterward that he didn't write it. So there seems to be a consistency here.
Did Trevor Clark order hearing officers in your disciplinary cases to bind the cases over to the RIB?
Yes, he did.
How do you know this?
Sergeant James Maggard was my unit sergeant at Warren Correctional, WCI. And he was then my hearing officer on the vast majority of the conduct reports. He personally showed me the emails that he received from Trevor Clark on his computer. He would bring them up and then flip the screen around to let me read those emails. And some of the emails that were not to him, he was CC'd, and they were actually to other people in the disciplinary process. So I got to read those too.
So Trevor Clark repeatedly corrupted the disciplinary process by directing the hearing officer's actions and foreclosing on their proper discretion.
Yes, he didn't leave anything to chance.
Okay. And you did see all those emails.
Yes.
Okay. If you know, are those emails discoverable?
No, those aren't discoverable. Those aren't discoverable in civil litigation because Trevor Clark's an attorney. So emails to and from ODRC Legal are exempt due to attorney-client privilege. They can claim it's legal advice whenever he's emailing someone.
Who told you this?
Trevor Clark, December of 2016, when he came to Warren Correctional Institution. He met with me and he said, go ahead and sue. None of that's discoverable.
So you assert that a deliberate pattern of corrupt practices was undertaken with legal counsel as the center actor, and it was a deliberate strategy?
Oh, yes, I know it.
So bound over to the RIB, You would have a hearing.
Yes.
Present a defense.
Yes.
Call witnesses.
Yes.
Question the ostensible charging official.
I lost you for a second there.
Question the ostensible charging official.
Yes.
So you were provided due process?
No.
Why not?
Um, Most often in these cases, the narrative, the factual narrative that was presented to support the charges, had nothing to do with the charges. Um, the narrative did not support what the charges claimed I had done. So that's the first thing. The second thing is, apart from the conduct report itself, there would never be any evidence presented to the RIB, nothing that would indicate guilt, just the conduct report. And the third thing is that due process does not apply in an RIB hearing.
What do you mean due process does not apply?
The U.S. Supreme Court ruled in Sandin versus Connor, 1995. The citation is 515 U.S. 472, that prison officials must provide an opportunity to give a defense. They must allow me to question witnesses. They must allow me to question the charging official. And if all of that happens, then the outcome cannot be challenged in court, because due process does not apply in an administrative hearing in prison. And it doesn't apply because any punishment that is given out by the RIB does not constitute what the Supreme Court called a significant and atypical hardship. So, since it doesn't change the conditions of confinement significantly, if you're at minimum security or supermax security or whatever they can do to you, there is no violation of due process. There's no violation of civil rights. And so the U.S. Supreme Court in that case essentially foreclosed on bringing civil rights actions related to administrative disciplinary hearings.
Who told you due process does not apply?
First was Lieutenant Keith Dolby, who was the RIB chair at Mansfield, and then the RIB chair at Warren Correctional. I don't remember his name. He was a lieutenant, and he was the permanent RIB chair until he resigned from the ODRC and took a job as a manager at Staples across the street. He's the one who specifically instructed me. You know, they would all say the same thing. All the RIB chairs I've ever encountered would say the same thing at some point during the course of the proceedings. They would say, "You do know due process doesn't apply here." They would always bring that up specifically. The lieutenant who worked at Warren Correctional and later quit, he's the one who told me to look up Sandin versus Connor. And I'm fairly certain, since he's a manager at Staples now, that he's not a lawyer. So I have to imagine that he was trained in what he was allowed to do and not allowed to do. And the people who do the training is ODRC Legal Services.
ODRC Counsel, the office where Trevor Clark worked, trained RIB chairs that due process did not apply?
Yes.
What else did the RIB chair disclose to you?
So he explained how the charges, why I was charged with specific charges in order to facilitate a guilty finding.
What about the charges?
So something he pointed out to me is that there's something like 74 defined rules that constitute the inmate rules of conduct. Only 7 of them have definitions. So we're talking about undefined behavior. So since there are no definitions, everything is incredibly subjective. So, however he wants to interpret what something means, that's what he can do. Um, yeah. So, he pointed out specifically things like extortion and so on that we'll get to here in a hot minute. Yeah.
How does that impact the process?
So, let me give you some examples. There is a rule against contraband. You can't possess contraband. I was several times charged with contraband. In one of the cases, I was charged with contraband. I was charged with contraband for possessing my own radio script for a radio show that I had recorded. It was written on this same kind of paper right here that you buy from the commissary. And I was taken all the way to the RIB for a contraband ticket that's normally resolved at a hearing officer level. And I was found guilty of contraband, and it kept me at Warren Correctional for another year. And when I asked him after the hearing was over, how can you find me guilty of contraband for possessing my own property? And he told me, he said, well, contraband is defined in part anything that's been modified since the time that you purchased it. And you wrote in ink on the paper, and that ink wasn't on the paper when you purchased it. Therefore, it's contraband. And this isn't an unreasonable reading of the rule. The rule does actually say that. If you buy a bag of chips from the commissary and you open the bag of chips in order to eat the potato chips, you now possess contraband. And it's contraband because it wasn't open when you purchased the bag. They can actually confiscate your bag of chips, write you a conduct report, and probably eat your chips. So that's contraband. Then rioting is not defined. I've been responsible for 3 riots. I've never been involved in a riot. I wouldn't know what to do in a riot. If a riot actually broke out somewhere, I would lock down in my cell. I would be afraid. There would be violence. I don't want to be part of a riot. But I'm responsible on paper for 3 riots because rioting is not defined. If I write a letter home to my mom, and my letter home to my mom is something very disgruntled that could make her mad, that can be construed as inciting to riot because it doesn't say who you're inciting. I could be inciting my mom. So so the rule's not defined. I can be found guilty 3 times of rioting. There is participating in unauthorized group activities, which is supposed to be gang activities, right? But it's so broadly defined. Any 2 people who share a common interest and act in collusion with one another. So if you have 2 Cleveland Browns fans in the day room watching TV and the Cleveland Browns score a touchdown and they both cheer at the same time, that's gang activity. Because Cleveland Browns are not an authorized group by central office. Central office has not approved you to be a Cleveland Browns fan. So every category of human interaction can be understood as gang activity for purposes of the rule. Encouraging a work stoppage isn't defined. Extortion. I've been found guilty of extortion twice. This is the constellation of disciplinary charges that the parole board's talking about when they extend me for 5 more years. Is my rioting and gang activity and contraband and extortion, right? I've been twice found guilty of extortion. Now, this is the definition of extortion: acting with purpose to obtain anything of benefit or value. Acting with purpose to obtain anything of benefit or value. That defines any human conduct. If I'm walking to the chow hall fast so that I can get a hot tray and I walk there faster than the other guy, I'm acting with purpose to get something that I find of value. Extortion. So anything a human being does is extortion. And this is something that the RIB chair pointed out to me after finding me guilty of extortion. He said, you have to read the rule. That's why they're charging you with extortion, is because anything you do can be construed as extortion given the way that the rule is written. Um, also, disobedience of a direct order. I've been found guilty of disobedience of a direct order. I was in the military for a time. You have an obligation in the military to obey direct and lawful orders. Mm-hmm. There is no such qualification in the ODRC. It's only a direct order. It is not up to you to decide whether the order is lawful or not. So you have an obligation to obey unlawful orders. It's not up to you to decide. So if you're told to do something unlawful, if I'm told to punch some guy in the face and I don't do it, I can be written up for disobedience of a direct order, taken to the RIB, stuck in SEG for not punching a guy in the face, because it's not up to me to decide what's lawful and what's not. Disobedience of a direct order is written that way. So even the 7 definitions they do have, many of those are so expansive as to, like extortion, acting with purpose to obtain anything of benefit or value. That constitutes every human behavior.
What about the burden of proof to find guilt at RIB?
So the burden of proof is some evidence. And it should also be pointed out that the conduct report itself is evidence. So you walk in with a copy of the conduct report. The conduct report itself is evidence.
So that means when you walk into the RIB hearing room, you're already guilty?
Yes. And the RIB chair actually explained this to me. He told me, after finding me guilty of some outlandish stuff, and we were off the record, he pointed out, he said, haven't you noticed that when you first walk in to an RIB hearing room, we ask you if you've been served a copy of the conduct report? He said, that's because we want to know. You've seen the evidence. You're carrying it in your hand when you walk in the RIB room. He said, since we only need some evidence, and since the accusation itself is evidence, you walk in the room guilty, because you're walking in the room with the evidence right in your hand. He actually turned the monitor around and let me see, as he was scrolling down, all of the cases and their dispositions. Guilty, 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 guilty. He said he'll find somebody not guilty on occasion, just as a matter of grace, because whatever he's accused of didn't really matter to him, and it seems as though he really didn't do anything wrong. He'll find a not guilty every once in a while. But he said he doesn't have to. He can find everybody guilty. When I went into the SMP at Warren, they had a 100% guilty rate. 100%. They had never, ever found anyone not guilty. So it's because the conduct report itself is that, and if you look at the disposition of the RIB in all of my cases, it will say something about, we believe what's written in the conduct report, the conduct report, the conduct report. That's all they'll ever make reference to, is the conduct report, because it's evidence, the accusation itself. So from the time Trevor Clark puts pen to paper, right, and writes down, Sean Swain did this, it's a foregone conclusion, essentially, even without his direct intervention. It's a foregone conclusion. I'm guilty.
And that's based upon what the RIB chair at Warren Correctional disclosed to you?
Yes.
So taken together at RIB, due process does not apply. Guilt can be assumed because none of the charges are defined, or they are expansively defined. And the conduct report itself constitutes evidence of guilt?
Yes.
Do you know if Trevor Clark ever influenced the decisions of the RIB?
I do. Um, the RIB chairs would say so. In Mansi 12-7219, he was the co-charging official. He was counsel to his co-charging official, and he was the consultant to the RIB, so he was there during the deliberations on the conduct report that he wrote. At a number of other hearings, after the hearing was over and I was found guilty, they would shut off the audio and say, Swain, there's really nothing I can do. It's out of my hands. And I would ask why, and they would say, Trevor Clark. This was an open secret. This wasn't something they even attempted to hide because they didn't want to be. They felt ashamed. I sensed they felt ashamed for what they were doing to me. They didn't like it. And also, Sergeant James Maggard showed me the emails quite frequently, showing me what everybody was being told that they were supposed to do. They were given instructions.
Since Trevor Clark's termination in 2019, has this corruption of the disciplinary process ceased?
No. So I would turn your attention to OSP 22-320 and OSP 22-371. In one of those, just to give an example, my finger was chopped off in a botched rendition to Maryland, and I was at the hospital. Then Warden Richard Bowen didn't want to pay the hospital bill. So he sent what began as an email chain to Deputy Warden Mark Thomas and to Major Jeremy Ift, instructing them specifically on a narrative to be written about me that would constitute a conduct report. And I was to be charged with lying. And the narrative is that I was laying perfectly still at the hospital with my eyes closed and not speaking. That's literally the narrative. And so I was pretending to be unresponsive. Now, medically speaking, there's only two states you can be in. You're either responsive or you're unresponsive. There's no such thing as pretending to be unresponsive. You are unresponsive. If you're not responding, you are unresponsive. And so based on that, this contrivance of a rule violation, he believed he would get out of paying the hospital bill. What he didn't know is that he didn't have to pay the hospital bill anyway. It's paid for by some state program that the ODRC already signed me up for. So he's doing this for no reason at all, it turns out. But he sent the email chain to the deputy warden and the major, instructing them as to what the conduct report would say, how the sergeant would bind me over to the RIB, and how RIB would find me guilty of lying and impose the penalty of restitution. This is what he ordered. The email chain went from Mark Thomas and Jeremy Ift to Lieutenant John Zubik, who became charging official, and he wrote word for word exactly what the warden had instructed to be written in the conduct report. Sergeant Cassidy was the hearing officer and bound me over as instructed by the warden, and RIB Chair Joseph Santha found me guilty of lying and imposed the penalty of restitution, just like Richard Bowen told him. And I have the emails. I have Richard Bowen's own emails setting forth this entire process and instructing on what to do.
Okay.
Yeah.
And that email chain is in the exhibits?
It is.
Okay.
Yes.
Why do you have Richard Bowen's emails but not Trevor Clark's?
Because Richard Bowen isn't an attorney. Clark is. So Bowen's criminal plots are discoverable, but Clark's are not.
Okay. With the Bowen emails, did you appeal the RIB findings in OSP 22 371?
I did.
To whom?
First to Richard Bowen, the guy who wrote the emails.
And then to whom?
To Byron Turner of ODRC Legal Counsel.
Did he reverse?
No.
Did
He
you
said that the corruption was irrelevant.
did you challenge this in court?
I did. Swain versus Bowen, Franklin County, case number 24 CV 5383 before Judge David C. Young.
So
Uh, mhm.
go ahead. I'm sorry I
Yeah,
interrupted.
I didn't have a claim for which relief may be granted. Again, we're back to Sandin versus Connor. You can't challenge RIB.
So probably this influence exerted to weaponize the disciplinary process is just an accepted component of how it is designed.
Yeah, yeah, it's business as usual. It isn't broken. It's designed this way. It's on purpose. You have to figure that it's ODRC counsel who authors up 5120, the administrative code. They're the ones who have the influence over how this is written and what it says. So once it's codified, they're the ones who can easily find all of the so-called hacks for doing end arounds and getting the end results that you want for using this process that they've developed themselves.
So to sum it up, Trevor Clark, who you accused of a Prison Rape Elimination Act violation, covertly authored all of the disciplinary accusations, outsourced them to others, directed officials in the process to come to a predetermined conclusion in hearings where charges are either undefined or expansively defined, where simply being charged constitutes sufficient evidence for a finding of guilt and due process does not apply.
Yes.
You have filed civil actions to challenge this.
I have. I've tried. They've been dismissed.
And
Um, uh, I have no claim for which relief may be granted. We're back to Sandin versus Connor.
why not?
Well, because of Sandin versus Connor, I'm not entitled to due process, and so essentially, what the courts are saying, and they're right. They're right. Is that the ODRC can turn their RIB process into a clown show if that's what they want to do. They're entitled to just run the little red car right into the center ring and let the clowns pour out and kick each other in the pants and squirt each other with their plastic flowers. And if that's what they want to do for a disciplinary process, that they can do that. And I'm not entitled to anything more than that. And they're right. I'm not, because of Sandin versus Connor.
What is your issue?
So my issue isn't that there's no due process at the RIB. My issue is that the parole board owes me due process. So if the ODRC wants their disciplinary process to be a clown show, that's all good and fine. But you can't put a clown show in front of the parole board and let the parole board rely upon the determinations of the clown show in order to give me a continuance of 5 years, because I have a meaningful opportunity. I have due process at the parole board. So the parole board itself cannot rely on processes where due process did not apply.
So you're saying that because due process is implicated at your parole suitability hearing, the parole board violates due process when relying upon disciplinary findings where due process was not implicated or applied.
Yes.
And so the absence of due process at disciplinary hearings when presented to the parole board violates your right to due process at the parole hearing.
Correct.
Do you also assert that Trevor Clark's weaponization of the disciplinary process after you made a PREA claim against him constitutes PREA retaliation?
Yes, it's Prison Rape Elimination Act retaliation. Yes.
Have you made an independent PREA allegation relating to this retaliation?
I've attempted to several times.
Tried.
Yes. So I contacted the ODRC on March 1st, 2019. And on March 11th, 2019, they acknowledged my retaliation claim.
How was that resolved?
On April 14th, 2019, I was shoved in a van and sent to Virginia without any process at all. So, so what they did was when I showed them that I was aware that this is a PREA violation, all of the things that they're stacking on me in terms of the disciplinary contrivances that were engineered by Trevor Clark. Once I brought that to their attention, they shoved me in a van and got me out of the state without any process at all.
So, to your knowledge, the PREA retaliation that led to your disciplinary record was never investigated?
Correct.
After your return from rendition in 2021, have you attempted to raise PREA retaliation claims relating to the weaponization of the disciplinary process undertaken by Trevor Clark?
I have.
And what happened?
They refused to investigate. They blocked my ability to make the claims.
The letter from the ODRC acknowledging your PREA accusation in 2019 is Exhibit 35.
Yes.
Your PREA kites and ODRC responses are Exhibits 36 through 43.
Correct.
Okay. WCI 18 004964. We have done an overview of the disciplinary process and also the strategies and tactics employed to weaponize that process, creating justification for elevating your security and depriving you of programs you require to gain parole, and manufacturing the false narrative that you're a disciplinary problem. So, why don't we now focus on a specific disciplinary action designated the WCI 18 004964?
Okay. Yes.
Is this is the disciplinary action that preceded your illegal transfer to Virginia?
This is. Yes.
It is the disciplinary action that the ODRC now claims was the justification for that transfer?
Yes.
And this is the final disciplinary action initiated and managed by Trevor Clark before the ODRC terminated him?
Yes.
And this disciplinary action was considered by the parole board in 2021 when it decided to continue you for 5 years?
Yes. Expressly in the hearing. Yes.
Reading the decision of the parole board, Exhibit A, to defendant's summary judgment in Swain versus parole board, it would appear that this disciplinary action is what they reference repeatedly when they describe a constellation of institutional misconduct and disruption to the institution and disruptive behavior and serious infractions.
Yes.
So a proper presentation of WCI 18 004964 is determinative in both Swain versus Chambers Smith and Swain versus Parole Authority.
It is. Yes.
All right, May 2018, you were held at Warren Correctional.
Yes. I had been there since 2015, and we have a yearly review. Mine were in July. So the contrived disciplinary during each of those review periods would keep me at level 3. So from 2015 onward, you see at regular intervals, I'm getting these contrived disciplinary findings that keep me at an elevated security that stops me from getting to level 2 medium security. In May
Hold on, you froze.
18.
Okay, there you go.
Okay.
In May of
Am I good?
2018, you're good.
In May of 2018, I was 2 months away from my next security review. And unless there was some intervening disciplinary action that would cause my security review to keep me elevated at level 3, at that point in 2018 in July, I would drop to level 2. I would go to medium. I would be eligible for programs, and I would see the parole board in 2021 with significant programs at a level 2, and I wouldn't be a disciplinary problem. So that would have greatly increased my chances of getting a parole. So that was May of 2018 at Warren.
Did you file civil actions in May of 2018?
I did.
Can you
Um,
describe those?
yes, I filed 2 civil actions. One was in Warren County and one was in Franklin County. And um, both of those named Trevor Clark and Lieutenant Kevin Chamberlain. Lieutenant Kevin Chamberlain worked at Warren. Trevor Clark was OTRC counsel. Sergeant Maggard had showed me emails from Trevor Clark to the mailroom, directing the mailroom to steal my incoming mail and to do so on the basis that anyone who was writing me was in my gang. Lieutenant Kevin Chamberlain, who was at Warren Correctional, was the gang coordinator and had essentially signed off on approving this action against me. So I filed the civil actions in both counties um, that alleged collusion to target mail of the people who loved me, constituting a gang. Yeah, so that's what those actions were.
Both of those civil actions were filed on the court's dockets,
Yes, yes.
and service copies were served on.
Lieutenant Kevin Chamberlain and ODRC counsel Trevor Clark.
Did you request discovery?
I did for Trevor Clark, and I sent that discovery to him.
Did discovery include admissions and interrogatories relating to the PREA violation that Trevor Clark committed and his campaign of PREA?
You're still frozen.
There you are. Okay, we'll start all over. Did discovery include admissions and interrogatories relating to the PREA violation that Trevor Clark committed and his campaign of PREA retaliation?
Yes, yes. The specific questions about those particular incidents were sent to Trevor Clark.
What happened next?
Within a week of Trevor Clark being served in both cases, I was placed in segregation.
What reason was given for punitive action?
None. There was no reason given. I was simply put there under investigation. And when Lieutenant Chamberlain came to talk to me, he told me I was under investigation on orders of Trevor Clark.
When did this happen?
I believe it was a Saturday morning. It was, I think, June 12th, 2018.
How did you respond?
I complained that this was PREA retaliation by PREA violator Trevor Clark, that he was having me tossed in the hole, and that it was also retaliation for my right to access, for exercising my right to access the courts, because after I had filed the civil action and he was served, he had me tossed in the hole. And I told that to Warden Shea Harris. I told that to Lieutenant Chamberlain. I told that to the institutional inspector. I think her name was Cynthia Barnes. And I told it to others.
What did they do?
There was nothing they could do. Trevor Clark is at central office. He's legal counsel, and he trumps anything that they wanted to do.
Okay. So what did you do?
I declared a hunger strike. I stopped eating. And this isn't something that I like to do because I like food. But I also had to get home to my mom and dad. You know, I've been locked up for a long time. They've been waiting for me to get home. At that point, I was less than 2 months away from a security review that would let me get lowered and go to medium, get programs, and get a parole in 2021. So that was important to me. So I went on the hunger strike because I was just in the hole without any charges at all. I hadn't done anything.
Our first question is, can you explain under investigation?
Yes. So this is a kind of hack that's built into the Ohio Administrative Code. So in all other instances, you have to be charged with something in order to be placed into SEG. But there's a catch-all under investigation that all they have to do is say they're investigating you and they can throw you into SEG. At the time that we're talking about, they could put you into SEG for 21 days under investigation and then extend it for another 21 days. And that means you're just in SEG. You're just in the hole and nobody knows why. And you can be there up to 42 days without anyone actually giving you a reason for it. So essentially, um, under investigation is a euphemism for you're being punished and they're looking for a justification.
So you did not receive a conduct report?
No.
Can you describe what happens in relation to hunger strikes in the ODRC?
Yes. So at that time, how it worked, you had to refuse meals for 3 consecutive days. It was a total of 9 meals consecutively. And they would declare you to be on a hunger strike. And at Warren Correctional, they would move you to the med clinic and put you in an isolation cell in the med clinic. Um, then you would, on a weekly basis, meet with the Hunger Strike Committee. I called them the Hunger Games Committee. The Hunger Strike Committee consisted of at least one deputy warden, the major, the ship captain, the doctor in charge of your medical care, a nurse, a mental health supervisor, the unit management administrator, and generally it's everybody who runs the prison sits down to talk with you once a week in the Hunger Strike Committee. Yeah, so that's what that is.
And what do they do at hunger strike committee meetings?
Um, the, uh, the gist of it is this: they ask you what you want, you tell them, and they say, "Okay, talk to you next week."
Okay. You attended a hunger strike committee meeting?
Yes, I did, and I believe it was June 18th, 2018.
And then the following day,
The following day, I ate food because I realized how useless it was to be on a hunger strike. And that evening, I was released from segregation after 7 days in SEG.
you returned to population at Warren Correctional.
Yes, that was June 19th, 2018. Um, and so once I returned to population, that indicates that the investigation is over and the pursuit of disciplinary whatever it was, based on whatever it was also over. And so that would mean coming back into population that I was back on track to have a security review in July and probably get dropped to medium security and be able to get programs and earn a parole.
How long were you in the population?
1 week from my release on the 19th.
And what happened?
Lieutenant Chamberlain, who was one of the defendants in the cases I had filed, Lieutenant Chamberlain ordered me sent back to SEG under investigation again, and he told me specifically that it was on orders of Trevor Clark.
This would have been at the end of June?
Yes, and it was on a Friday, so I'm thinking it was June 25th, 2018, I think.
So after suing Trevor Clark and Kevin Chamberlain, they put you in SEG without charges, and you saw the hunger strike committee, got released from SEG, and a week later you were put back in SEG on orders of Trevor Clark, carried out by Kevin Chamberlain, the two administrators you were suing.
Yes.
At this point, by rule and policy, there should have been a conduct report written to justify your segregation. And that conduct report should have been served on you by a hearing officer, correct?
Yes.
Did that happen?
No.
What happened instead?
So, without the conduct report, I remained in SEG for an extended period until sometime in August. And then in August, they took me directly to a serious misconduct panel hearing without ever serving me a copy of the conduct report or telling me what I was charged with.
So they simply skipped service of the conduct report.
Yes.
And you said you were taken to the SMP rather than the RIB.
Yes.
How was the determination made?
Greg Kraft was the warden's assistant at Warren Correctional Institution. And so I had an opportunity to speak to him at one point and ask him, since he's the one who makes those determinations, what happens. And what he described to me was he looks over the conduct reports and he reads them and he puts them in two separate stacks according to however he feels about them after he reads them. And mine went into the serious misconduct panel stack.
And what criteria was applied to distinguish serious misconduct warranting referral to the SMP from RIB cases?
Well, if you're talking about under the rules, there's none. And if you're talking about under Greg Kraft, it's his personal feelings about what he's reading. That's what distinguishes them.
So, absent service of the conduct report and based on personal and subjective judgment of Greg Kraft, you appeared at the SMP.
Yes. Now, also, it's important to note, because we haven't actually gotten into the nuts and bolts of this, but in my case, I was accused of writing an article that was posted online, and then I was accused of making a threat at the Hunger Strike Committee. Just to give an example, at the same time, there was a prisoner named Barnes. He had been in possession of meth. He had been up for 8 straight days without sleeping and was behaving bizarrely. So the COs went to shake his cell down. And when they patted him down, he had 2 knives on him that he didn't want them to find, shoved down the legs of his pants. So he struggled with the officers while in possession of knives. And they subdued him and then found meth in his cell. And he was sent to the RIB, a guy who was in possession of weapons and drugs and fought the police while armed with knives. Went to the RIB. I was accused of writing an article and making a threat at the Hunger Strike Committee, and I was sent to the SMP. So I asked Greg Kraft about this, and his exact words were, "Well, Trevor Clark thinks you're a special case." And so, if that clues you in on what the distinguishing thing is. Now, when I appeared, so yeah, I then appeared at the SMP as a consequence of that process.
Did you have an opportunity to present a defense?
No. I didn't know what the charges were. So I was flying blind. I went into an SMP hearing without knowing what the charges were. So there's no way for me to defend against something that I haven't heard. So no, I didn't have an opportunity to present a defense.
Were you permitted to call witnesses?
No. The hearing officer is who arranges for the sheets to be filled out for each witness. And since those weren't filled out because I never got heard on the ticket, on the conduct report, I didn't have any witnesses listed, so there were no witnesses I could call.
Were you allowed to question the charging official?
No. Lieutenant Kevin Chamberlain is the one who signed off as the charging official, even though Trevor Clark wrote it. And Lieutenant Kevin Chamberlain was standing right outside the hearing room. And I pointed that out during the hearing. I said, "Well, he's standing right out there. You can just call him in here." And they said, "Well, no, you never told the hearing officer you wanted to question the charging official." And I said, "Well, I was never heard by a hearing officer, so there's there's no way I could have." So they denied that also.
What was the SMP decision?
Guilty on all 3 charges: rioting, gang activity, and extortion.
Did the SMP recommend out-of-state transfer?
No.
So, to your knowledge, based upon the penalty imposed by the SMP, this disciplinary action could not be used to justify your transfer to Virginia.
That's right. That's right.
Did you appeal the SMP decision?
I did.
What was the result of that appeal?
It was reversed and remanded.
On reversal, did you return to the SMP for rehearing?
I did not.
The SMP never reheard this disciplinary case?
No.
What happened next?
Um, so I was still in SEG. The SMP decision had been reversed, so I didn't have a charge. Um, and I was waiting to get back out into population. Um, I'm not going to reveal here the names of the prisoners. I can at some point, but I'm just going to call them Prisoner A and Prisoner B. Um, so, Prisoner A was at the Southern Ohio Correctional Facility, and I had known him from his time at Warren. I had done legal work for him. So, Prisoner A wrote a letter to Prisoner B. Prisoner B was at Warren Correctional with me, and told that prisoner, Prisoner B, that he had overheard security staff at Lucasville, SOCF, talking about my arrival soon to happen at SOCF, that they were going to put me in a block called J1, where there are no security cameras, and they have double doors on the cells. So other prisoners in other cells don't know what's happening in any other cell. So there are no witnesses. And he said that they planned on hanging me from my bed sheet and framing it as a suicide, and to warn me that that was coming. And he warned me from Lucasville after hearing the guards talking about it.
Did you believe the letter?
Oh, absolutely not. There was no basis. I'm at close security at Warren. SOCF Lucasville is maximum security, and there's no basis for me getting elevated in security because my SMP was reversed. So I'm not going anywhere. I thought he was nuts. I didn't pay any attention to that at all.
So that's why you didn't believe it?
Right. There was, I had no SMP conviction. There could be no security level raise, and I couldn't go to SOCF. I mean, under the rules, it's just not, you can't get there from here.
So then what occurred 2 weeks later?
My name appeared on the SOCF transfer list.
What did you conclude from the events and their timing?
Um, Based upon the letter happening 2 weeks in advance of me being put on the SOCF transfer list, I concluded that somebody at ODRC central office had to have made an arrangement and told people at SOCF that I was coming. And since they were talking about killing me, I have to imagine that the only reason they would have had for intimating this information was to arrange for that from central office. Um, and I can think of no other explanation for how SOCF staff would know of a transfer before it was ever officially decided at central office.
How did you respond?
Um, I told friends and supporters of the murder plot, and they posted things online, and they started phone bombing the ODRC and senators and representatives, and they made enough of a stink um, that, um, that the ODRC had to realize that I knew of the murder plot.
And what happened?
One day before the SOCF transfer, um, my name was switched to the OSP list, Ohio State Penitentiary.
The Ohio Supermax prison?
Yes.
Did you appeal the transfer to higher security?
Yes.
And the result?
I won that appeal because I didn't have an SMP conviction. There is no way to raise my security. So I won that appeal also.
What happened next?
They shoved me in a van and sent me to Virginia.
Okay, before we go any further, to recap, you sued Trevor Clark. He then ordered you placed in segregation. You attended a hunger strike committee meeting. You were released from SEG that next day, then put
Yes.
back in SEG a week later. Then you were
Yes.
taken to an SMP hearing without even knowing the charges. without a chance to
Yes.
prepare any defense, and you were
Right.
found guilty. You won the appeal, and after learning of a plot to kill you at Lucasville, you were irregularly placed on the Lucasville transfer list despite your SMP conviction was being reversed, and you were
Mhm.
transferred to OSP before
Yes.
getting illegally renditioned to Virginia without notice or process.
That's right.
So, apart from that succession of events, did you ever have a chance to read the conduct report?
I have. Yes.
And is that the conduct report that the defendant provides as page 9 of Exhibit B in Swain versus Parole Authority?
Not really. No.
No? Then what is page 9 of Exhibit B?
That is the first page of the conduct report that was written against me.
How many pages was the conduct report?
Five. And they conveniently left out the part of the conduct report that thoroughly impeaches the conduct report.
Can you explain that?
Yes. So, um, in the conduct report, I was charged with 3 rule violations: extortion, rioting, and unauthorized group activity, which is gang activity. So, extortion, rioting, gang activity, those are the 3 charges. Um, and just for anybody keeping score at home, this would be my 5th gang activity, my 3rd riot, and my 2nd extortion. Um, even though I've never belonged to a gang, I've never seen a riot, and I've never extorted anybody. Um, According to the conduct report, there were 2 incidents that are described. The first incident described in the narrative of the conduct report is that on May 18th, 2018, there was an article that was posted online at my direction or something. Somehow I'm responsible for what's happening online. Um, and the article explains how to use drones to drop guns into prisons. That's the first.
Do you have internet access?
No.
What do you know about drones?
What I've seen on TV about drones.
Did you write
No
the
direct expertise at all. No.
Did you write that article?
No.
Did you order anyone to post that article?
No, and I don't know who I would have the authority over to give orders to post anything.
Did you locate the writer of that article?
Yes. At the time, Pam Starcia was my counsel, and she contacted the site where the article was posted, and she got the writer's sworn statement um, that that writer had written the article. She contacted Cynthia Hill, who was the institutional inspector at the institution at Warren, to ask if she could fax or email the sworn statement to her so that I would have it available at my rehearing at the SMP. Cynthia Hill contacted Trevor Clark to ask if she was allowed to do that, and Trevor Clark said no, not to block all communication from my counsel of any evidence that would exonerate me at the SMP. Um, and I saw that email, by the way. Then, when they realized I had located the actual author of the article, they canceled the SMP rehearing altogether, which is why I never had the rehearing, is because they realized that I had evidence to impeach him.
Okay, so to be clear, the conduct report accused you of writing an article you didn't write, and when legal counsel located that article, the actual writer, and obtained a sworn statement, Trevor Clark ordered Cynthia Hill to not make that sworn statement available to you at SMP rehearing and then canceled the rehearing altogether?
Yes, that's right.
Now,
Uh-huh.
now you said there was a second allegation in the conduct report.
Yes. So there were 2 allegations. The first was that I had written an article that was posted online, and I directed others to post it about things that I don't know anything about. Was It's described on pages 4 and 5 of the conduct report, which appears in the exhibits. And according to pages 4 to 5, it describes the June 18th hunger strike committee um, that I attended. Now remember, I was placed in the hole, I think, on June 12th, June 13th, June 12th maybe, without a charge. And so I went on a hunger strike, saw the hunger strike committee. This is before I was let out and locked back up again. So it's during that hunger strike committee, according to the conduct report, that I was in the room. Remember, the hunger strike committee, how it operates, I'm in the room with like 2 deputy wardens, a major, a captain, a head of mental health, the head of medical, maybe the king of Denmark. It was a crowded room. And during this hunger strike committee meeting, I threatened to burn down the homes of Trevor Clark and director Gary Moore if they didn't stop my interstate transfer. That was the accusation.
So it was the alleged threat to burn down Gary Moore's and Trevor Clark's houses that constituted the extortion charge?
Well, I imagine so. Burning down someone's house seems pretty extortive to me.
Did you threaten to burn down their houses?
No, no. So remember, this hearing was on June 18th. I was released from segregation the following day. So their records will show this. I had a hunger strike committee meeting on the 18th. I was released from seg on the 19th. Also, I think it's important that you recognize that time is linear and it's unidirectional, right?
Okay.
The past is always the past and the future is always the future.
Right.
So it's a temporal impossibility that I was raving about an interstate transfer on June 18th, 2018.
Okay. So the next question is why?
In order for me to be talking about an interstate transfer on June 18th, I would first have to have been given a charge. I would have had to gone to SMP. I would have had to have been found guilty. They would have already had to have raised my security status, and they would have had to have recommended an out-of-state transfer. None of that had happened. The process had not yet even begun. So what they're attributing to me before the follow me here, before the disciplinary process even got started, they're acting as though I have some psychic ability to know what's happening at the end of the disciplinary process. I couldn't possibly have been talking about an interstate transfer. At that point in time of June 18th, I had a clean conduct record. I was waiting till the following month to have a security hearing where I was going to get dropped to medium and go and get programs and get a parole. I would be talking about going to medium. I wouldn't be talking about going out of state. There's no contemplation of out of state transfer until you get through this process. So what they're attributing to me is a threat that I could not have made. And besides that, consider the hunger strike committee hearing happened on the 18th. I was released from SEG on the 19th. Is it even a rational possibility that I'm sitting in a room with deputy wardens and a major and a captain and all these people talking about burning down the director's house, and they respond by letting me out of SEG the next day?
Right.
That didn't happen.
Right.
It just didn't happen. So you don't even have to take my word for it when I say that didn't happen. It could not have happened. I'm talking about something I could not have even been contemplating, and it's happening in such a way that rationally it could never have occurred.
So what you're saying is, since your interstate transport could only be contemplated at the end of this disciplinary process, it would be impossible for you to have uttered the extortive threats about interstate transport attributed to you before any disciplinary process had so much as even begun.
Yes, exactly.
Why do you think that the defendant in Swain versus Parole Authority provided only 1 page of a 5 page conduct report?
Well, I can't speak to why they did it, but I know this. I know if I told a big fat lie on pages 4 and 5, I might only show you page 1, the same way they showed you page 1.
So, even apart from the irregular process employed in WCI 18 004964, you're saying the accusation itself was a profitable fraud or provable fraud. I'm
Yeah,
sorry.
yes, yes,
And that provable fraud was conducted by PREA violator Trevor Clark.
yes,
And that fraud was used as a oh my goodness, I'm having a word, justification to transport you out of state and obstruct the litigation you had filed against Trevor Clark.
exactly. Yes, provably.
And so this provable retaliatory fraud was used as the basis for your illegal rendition to Virginia.
Yes, as they're claiming now. Now, at the time that it happened, nobody said anything about why I was going to Virginia. They just tossed me in a van. But it seems that the Attorney General's office now is pointing at this disciplinary action as the justification. Retroactively, they're using that as a justification for what they did. Yes.
And this provable retaliatory fraud was used as the basis. I think I just did that one. No, basis for your continuance in your August 2021 parole suitability hearing.
Yes.
Okay. We turn now to your illegal rendition to Virginia. This occurred
Yes.
on or about April 14th, 2019.
Yes.
Please describe events leading to that transfer.
So we've already gone over the chronology of the events where I was put in the hole, hunger strike committee, let out of the hole, put back in the hole. Without the conduct report, I appealed that finding and won, and it was vacated. And then they tried to send me to Lucasville to kill me, and we discovered that plot, so they sent me to OSP instead. And I appealed that and won. And so I was waiting to get back to a level 3 where I would have a security review that would send me down to a level 2 and go to medium. And that's when they came at 4 o'clock in the morning on April 14th. They told me I could take my hand carry meds and I could take one folder of my legal work. And I asked them where I was going, and they said they didn't know. So they escorted me downstairs to R&D, receiving a discharge here at the prison, OSP, and two officers who were dressed in olive drab, the Vietnam era Army surplus kind of uniforms. They had no identification. They chained me up. I had shackles, handcuffs, belly chain, and they escorted me out to the garage. They stuck me in a black van, and I asked them where I was going, and they said, "Well, you'll know when you get there." Um, and we took off, and yeah, that's how the illegal rendition came to be.
Did you recognize staff driving the van?
No, no. In fact, they weren't wearing ODRC uniforms. They were wearing the green khaki Vietnam era. So I don't know who they work for.
Was there a logo on the van?
No, it was just a black van, no insignia.
After you arrived in Virginia?
So after I arrived in Virginia, I was at their reception center. Um, and I was called into an office. They had like a trailer, like a mobile home that was set up on the compound, and that had some offices in it. And there was a guy named Kyle Roush. Kyle Roush was the interstate transfer guy for the Department of Virginia, Virginia Department of Corrections, and he called me into his office, and um, and I spoke to him then, and um, yeah, I asked him, what's going on, and he said he didn't know. He couldn't tell me anything. He said I would have to contact the Ohio Department of Rehabilitation and Correction and get some explanation from them.
Did you contact the ODRC?
Oh yeah, several times. Sometimes by certified mail.
Any
Erlina
response?
Shepard. Uh,
In
Erlina Shepard was the interstate compact person for the ODRC.
Yeah,
So no response,
no
no
response.
answers
Okay.
to any of my inquiries.
At any time prior to your 2019 rendition to Virginia, or during your time in custody there until October 2021, did anyone from the VADOC or from the ODRC ever indicate to you that you were sent to Virginia pursuant to the Interstate Corrections Compact?
No.
Are you familiar with Ohio Revised Code section 512.50?
5120.50, yes. Um, that sets forth the Interstate Corrections Compact in Ohio law. Yes,
Have you read paragraph D of that statute?
I have. So, paragraph D says, I'm reading here from my notes. No transfer shall take place pursuant to this compact unless one of the following has occurred. And it lists two things. Small a, the inmate has given his written consent. And then paragraph small b says that absent giving written consent, a hearing shall be held and a record made indicating the reason for said transfer. So those are the one of those two preconditions has to be met by statute. Yes.
Did you ever give the ODRC written consent to be sent to Virginia?
Never.
Did you ever have a hearing related to transfer to Virginia?
Never.
Was there a record made?
Never.
Were you given a reason for the transfer?
No. Not even after the transfer happened.
Since there are statutory go ahead.
Oh, go ahead. Go ahead.
Since there are statutory preconditions for an interstate corrections compact transfer, and since no transfer shall take place pursuant to this compact, unless those statutory mandated preconditions are met, what does this mean about your rendition to Virginia?
Um, it says that no transfer shall take place pursuant to this compact unless one of the following occurred, and since none of the following occurred, that would mean no transfer took place pursuant to that compact. So I wasn't transferred pursuant to the Interstate Corrections Compact. I was kidnapped and I was transported across state lines, which is a federal felony. That's what happened. None of this. So keep in mind, this is what was threatened by Chief Counsel Stephen Gray in his May 2013, 2014 letter that he sent to Richard Kerger, that if I refused to drop my PREA claim against his colleague Trevor Clark, I would be interstate transferred. Um, so yeah, so that's what they did.
You allege it was not a lawful act.
No, it was not lawful because they didn't follow the statute.
And unlawful acts cannot be official acts.
That's right. So there's a quote that I love that's from an Ohio Supreme Court case called State versus Buttles. That's State versus Buttles 1854, and the citation is 3 OS 309. And this is the quote from the Ohio Supreme Court. when they're talking about whether or not illegal acts can be official acts. This is what they said. It would indeed be a great absurdity that the government should aid in the subversion of its own policy, assault those principles of virtue and morality it is created to uphold, or itself overthrow the law which it compels others to observe and which it was made to enforce. So, great absurdity is the idea that the Ohio Supreme Court, that's the phrase that they use to assign to an idea that the government acts that are unlawful. Um, and to make an analogy, um, because this is the argument they're essentially making right now, is that, 5120.50 is a law, and I was transferred according to that, and so everything's fine. And even if they didn't follow it, it's fine because that gives them the permission to do what they did. Um, so, an analogy to that, um, Mike DeWine is the governor. He has the authority to sign a death warrant and have somebody on death row executed. So if he signs the death warrant, that person will be escorted to the execution chamber and they'll be killed. And that's all perfectly legal under Ohio law. What Mike DeWine can't do is walk down death row with a baseball bat and look in cells and find somebody he doesn't like. He doesn't like the looks of that guy, so he drags him out on the range and beats him to death with a baseball bat. He can't do that. That's murder. That's not lawful. So even though he has the authority to kill somebody on death row, you can't say, well, the end result's the same, so it's okay that he pulled him out, beat him to death with a baseball bat. Sending me to Virginia without any kind of process at all is the equivalent of Mike DeWine beating a guy to death with a baseball bat. It's not legal, right? The end result is that I ended up in Virginia, which is what might have happened had they followed the legal process. That doesn't mean that it's the same as the legal process. The same way as signing a death warrant is not the same as beating a guy to death with a baseball bat. So, yeah.
How did you get returned from Virginia?
So I couldn't get an answer as to what I was doing there. So what I did, I filed a federal habeas as someone who was confined without a legal conviction or sentence. I filed that in the Virginia U.S. District Court, and the case was assigned to the Virginia Attorney General to respond to it. So the Virginia Attorney General apparently got all of the paperwork together, and um, this is third-party information now. Kyle Roush was at the reception center when I was sent back there in October of 2021. And he's the one who told me that he was contacted by the Attorney General's office, Virginia Attorney General. And the Virginia Attorney General said to him that nothing about this transfer was legal. The exact words Kyle Roush used was, "Get him the fuck out of here right now." so that's what the Attorney General essentially told Kyle Roush. They had to get me out of Virginia before an order to release me from their prison. So they sent me back to Ohio.
Since your return from illegal rendition to Virginia, have you had occasion to know how ODRC administrators themselves characterize your rendition to Virginia?
Yes. So first is Exhibit 47 in the exhibits. Exhibit 47 is an email from Tracy Reveal to Gina Wiley. Tracy Reveal is the Interstate Compact Coordinator for the Ohio Department of Rehabilitation and Correction. She's the one in charge of Interstate Corrections Compact. And the words that she uses to describe my transfer to Virginia, my transposes are illegal rendition. It's in her own email. So that's the first thing. Second thing is if it's attached, it'll be attached as Exhibit 49. I'm not sure how my attorney does this. It's an audio clip. It's a phone conversation. My ex-wife Lauren, now Lauren Swain, now Lauren LaRock, called Director Annette Chambers Smith and was in contact with her office. Was put in touch with Annette Chambers Smith's assistant, who then put her in touch with another assistant. I was on the phone at the time on a three-way call. I was listening in on the phone conversation, and this audio is a copy of that recording. And in that recording, Annette Chambers Smith's assistant's assistant looked up the information about me and my transfer to Virginia and said they don't have any that it's puzzling because all of the official paperwork that should have been done for that to happen, it wasn't done, and there was no reason stated for my transfer. So that means even after I returned from the transfer, they still hadn't concocted a rationale for having transferred me in the first place. So that means they didn't follow it. They didn't follow 5120.50. They didn't follow the law. There was nothing legal about it. And if it wasn't legal, it wasn't official. It was just a kidnapping. That's what they did.
So the official in charge of the Interstate Corrections Compact has characterized your transport as illegal rendition.
Yes.
ODRC and Director Annette Chambers Smith's office has also confirmed in a recorded phone call that the law was not followed when you were renditioned to Virginia.
Yes.
Are you familiar with ODRC policy 53-CLS-07?
Yes, that's the Interstate Compact policy that corresponds to Ohio Revised Code Section 5120.50.
Okay. The paragraph, this is not...
Numeral 6.
Thank you. B1
Yes.
of that policy requires the same preconditions to interstate transfer as those listed in Revised Code Section 5120.50, paragraph D, Section D.
Yes. Roman numeral 6B1 small b requires a due process review hearing and a record of that hearing. And Roman numeral 6B1 small d requires Director Chambers Smith to have determined that I constitute a threat to security or that I am a problematic placement. And so far, no documents indicating such a determination was made has ever been provided by the Attorney General's office. So we can only conclude that that determination wasn't made, and it seems that that's what that audio recording also indicates, is that that determination wasn't made, and so they didn't even follow their own policy. They didn't follow the policy.
At paragraphs Roman numeral 6D of that policy, the procedures for interstate compact transfer are set forth. How many of those were followed?
None.
Subparagraphs 1 through 7 address the due process hearing and preparation for transport under Interstate Corrections Compact. Were those followed?
No, none of them.
Subparagraph 8 and 9 require transfer with property and commissary funds. Were those followed?
No.
Subparagraph 18 requires your return from Interstate Compact to the Corrections Reception Center. Was that followed?
No.
After your return to Ohio, you were notified of an intended transfer to Maryland.
Yes.
And this was claimed to be under the Interstate Corrections Compact.
Yes. And that's the first time anyone ever brought up to me Interstate Corrections Compact was in the anticipated transfer to Maryland. Did they ever bring up Interstate Corrections Compact? This is the first time it was brought up to me, Interstate Corrections Compact. Yes.
Were you provided a hearing as required by statute and policy?
No. I was provided an informal hearing with Unit Manager Donna Crawford and with my then case manager Tracy Lamb. They are unit staff here at OSP, but they are not the people who were supposed to be doing this at CRC at reception. But they were sent to me at an informal hearing, not in the formal hearing that's required by statute or by policy.
This set of series is going to start with we turn to your parole hearing on April 25th of 2021.
Yes.
Okay, we turn now to your parole suitability hearing of August 25th, 2021. Was this your first hearing?
No.
When did you appear previously?
I previously appeared in 2005, 2011, and 2016.
When you appeared in 2005, do you recall the rationale explained to you for your continuance?
Yes, Jim Bedra told me that they considered my first time up to be early because I had only served 14 years, 14 and a half on a 20-year sentence. So they considered that to be early since I hadn't served the entire 20. So it was too early.
How many members were there?
Just one, Jim Bedra.
And he decided that releasing you at your first eligible date was equivalent to releasing you early?
Yes.
What about 2011?
Well, 2011 was a bit of an irregular situation.
How so?
So I had retained Andrea Reno as counsel. Andrea Reno had previously sued the parole board, and she had voluntarily dismissed the action when the parole board had changed its policies voluntarily. So the action was moot. And I came to know her through a prisoner. He went by Popcorn. His last name was Gray. And Gray was held at Mansfield in 2011 with me. Well, what Gray essentially did was create a Ponzi scheme. He got a whole lot of other prisoners like myself who were going up for parole to retain Andrea Reno. Andrea Reno had a $5,000, $10,000, and $20,000 package, representation package for the parole board. He had paid the $20,000, and he was getting people like me to pay the $5,000, so that all of that money could be accounted to him that she had brought in. So he was working a Ponzi scheme to get as much money as possible in. And he didn't tell me until later, but the purpose of that was Andrea Reno was the bribery agent for the parole board. What she would do is take in all that money. For Gray, she managed to get him an early review and got him released. And then all of the other guys like myself that Gray had brought to her all got continued at the parole board. So it was kind of like trading baseball cards, only it was prisoners. She was the person to do it because she had established herself as opposing the parole board. So she had told me herself that she had met with the parole board and they had had dinner with parole board members, and Gray filled in the rest of it, that they had worked out this scheme, that she would be the mediator for the parole board. When Gray got enough money together, she bribed the parole board. They got him an early release. He told me after the fact that this was the scheme because he felt bad and he wanted to make sure that my next time up, I went with a $20,000 package and bribed the parole board because that's the way to get out. So, yeah.
So, how was the 2011 hearing conducted?
Um, so, in both 2006 and 2011, I was asked about circumstances of my case and whether I felt remorse. But in 2011, they began asking me about posted articles, um, my critique of the prison system, and whether I considered myself a political prisoner. They were asking questions like that based upon what they were seeing online that was being posted.
How did those issues arise?
Uh, as I found out through public disclosure, internal emails, the ODRC has an internal intelligence unit. This internal intelligence unit searches for unflattering portrayals of the ODRC online and then equates journalism with terrorism. Um, and so that unit then shares its surveillance results with the parole board and others.
How do you know this?
I have hundreds of their internal emails. Um, I'm collecting them now. I'm trying to collate them now, and we'll share with the court in both pending cases, um, and probably post them online so Ohio taxpayers can see how their tax money is being spent on a sophisticated spy system designed to prevent the public from learning how their prison system is actually mismanaged.
What was the decision of the parole board in 2011?
In 2011, the local board voted to give me a full board hearing.
Can you explain these different mechanisms?
Yes, so um, when you first go up for your parole suitability hearing, you're appearing through a portion of the before a portion of the parole board, a handful of members, and it takes a majority. Um, I think it takes a quorum in order to come to a decision, and if they don't have that, um, then it will go to a COBR hearing, what they call a COBRA hearing, and that's the entire board deciding on what to do with you. Um, if if they vote at a lower level but don't have, in my instance, because I have a life sentence, they have to have a unanimous vote, and if they don't, it goes to that they can recommend you to a full board hearing. A full board hearing is a good thing for a prisoner. You get to present witnesses, you get to have counsel present, you get to make the arguments for your release. So a full board hearing is really important. A COBR or a COBRA hearing is terrible. So I was recommended to a full board from the local hearing.
You were recommended to the full board. Did a full board hearing occur?
No.
Why not?
Um, in the interim, between me seeing the local parole board and the final decision being made in my case, uh, the prisoner Gray had managed to collect up enough funds for Andrea Reno to bribe the parole board, and so their scheme of of denying these prisoners and letting Gray go was put into place. So the full board hearing didn't happen. They converted it to a COBRA hearing and gave me 5 years.
How did you learn of the bribery scheme?
Popcorn Gray. He's the one who had first got Andrea Reno for his counsel.
Did this surprise you?
No. Um, in the 1990s, the parole board had instituted what was termed super flops. They were giving prisoners a continuance of as much as 40 years on nonviolent crimes. So everyone knew that it was doom at the parole board. And at the same time that they were doing that, parole board members were using that threat of super flops in order to essentially extort the prisoner population. So they would accept bribes in order to let people out rather than give them super flops. And this scheme came to the attention of authorities. Federal authorities swooped in. A bunch of parole board members went to federal prison behind it because they were accepting bribes. So no, they were enriching themselves through corrupt practices going all the way back to the 1990s. That's sort of expected.
So, in the 1990s, during the period when the parole board was routinely handing out continuances that were called super flops, they were also accepting bribe money to release prisoners and thereby using the super flop threats to corrupt personal enrichment.
Yes,
And you assert that the parole board reconstituted its bribery schemes in the 2000s by using attorney Andrea Reno as a bribery agent,
yes,
and that a prisoner named Popcorn Gray, held at Mansfield in 2011, was granted an early hearing and granted parole as a result of this bribery scheme.
yes. And if you look at Popcorn Gray, he was a gang leader at Mansfield. He was the head of the Gangsta Disciples. He was the top guy for the Gangsta Disciples, and he had a drug ring that he was running from prison. He had staff members who were muling in the drugs. He was selling drugs in prison, and that's how he got enough money together to bribe the parole board. So they were accepting his drug money to let him out of prison. Yes.
And that Andrea Reno, as the parole board's bribery agent, essentially sold out several prisoners, including yourself, in a trade to accomplish the release of Popcorn Gray, who paid the bribe.
Yes,
Did you report this?
I did.
To whom?
The Ohio State Highway Patrol. Um, I contacted the U.S. Attorney's Office.
What happened?
Oh, nothing at all. No, no one wrote me back. No one talked to me.
Did you
Nothing.
did you later expose this publicly?
Yes, on the Final Straw radio show.
And what happened?
Uh, the ODRC shut down all of my communications to make me shut up, and Andrea Reno seemingly disappeared. Her office moved.
Was there an investigation?
Not that I'm aware of.
Who
Just into me.
who is Gary Croft?
Gary Croft is the former chief inspector of the ODRC, and I had filed a civil action against him for stalling on our grievance appeals and keeping us out of court.
When did he join the parole board?
1 month before my hearing,
When did he leave?
1 month after my hearing.
And he signed off on your 5-year continuance while you were suing him in a Cobra decision that was supposed to be a full board.
Yes,
You saw the parole board again in 2016.
yes.
Can you describe that hearing?
Yeah, so all of my communications were shut down at the time, likely because I had exposed the parole board's criminal corrupt scheme. Um, and so my kiosk access was suspended, and I had no notice or no forewarning of the hearing. I was just told that I had a medical Zoom call. So I was taken to the medical clinic and thrust into the room, and the parole board was there on Zoom.
This
Lasted
was
about 20 minutes.
oh,
Excuse me.
it's
Lasted
okay.
about 20 minutes.
This was after you exposed their bribery scheme on a globally syndicated radio show.
Yes, yes,
And you were black-sided for it?
yes.
And we get to August 2021. Prior to this hearing, how did you prepare?
Um, well, I had a great deal of community support. Um, my mom was there, and she did a video call with the parole board. Um, I was married at the time. Lauren did a video call with the parole board. Um, a whole bunch of friends of mine, the producer from the radio show that I do, um, people who present my art publicly online. Um, I had employment at the Library of Baseball Stories. That's Exhibit 25 is the letter from from Grace Lynn. They were offering me $18 an hour for 30 hours a week, and I would work from home as the director of development. Not too shabby. Um, I had a 3-bedroom apartment. I had clothes in the closet. I had transportation. I mean, I had everything that I needed, and I had a whole support network of people around me.
That's roughly 26,000 a year that you were offered.
Yes.
You had transportation closing, and you had already served 30 years on a 20 to life sentence for an act of self-defense.
Yes.
So let's turn to the hearing of August 25th, 2021. This was
Mm-hmm.
conducted remotely by a Zoom call.
That's right.
So please describe what happened from when you entered the room.
Mm-hmm. So I was in Virginia. So this had to be somehow wired through Ohio to Virginia to the prison I was at in Virginia. That's because they were all in Ohio. Um, so there was just me and a table and a television. And they had technical problems from the start. They couldn't figure out how to connect Ohio to the Virginia Department of Corrections, and from there to Buckingham Correctional. So when they finally worked it all out, I could only ever see one parole board member on the screen. There was just one guy that I saw. I couldn't see anybody else.
Can you describe him?
Yeah, black guy, kind of heavy set, sort of, 40s, salt and pepper hair, glasses, and a sweater.
You didn't see any other parole board members on the screen?
No, not during the entire duration of the hearing.
Did you take notes at your hearing?
Oh, absolutely. Copious.
So there were difficulties before the hearing even started.
Yes. Um, and during that time, by the way, I also took the opportunity to ask them if the hearing was recorded, and they told me that it was.
Okay, I was just going to ask, what did the parole member say?
Yeah, so, and I waited until the end of the hearing after they made their decision to tell them to preserve the electronic record for purposes of litigation, and that if they destroyed it, they would be guilty of tampering with evidence and obstruction of justice. I don't know if that's true, but that's what I said. But I waited till the end because I didn't want to say all that at the beginning of the hearing and tell them I'm suing them, just in case they like me.
And then the hearing began?
Yes. Once the hearing began, the parole board members started rattling off the months I had served.
Was the calculation correct?
No.
How many months?
They had me logged as serving 334.
And how many months had you served?
357.
A difference of 23 months?
Yes.
Did you raise that?
I did.
What did the parole member say?
He said to inform the Bureau of Sentence Computation, and if they adjusted it, then the parole board would adjust the total months and credit me and move my next parole hearing forward if I was going to have a next parole hearing.
And did they?
No.
What happened next?
The Bureau of Sentence Computation adjusted my time from 494 days to 1,200 days of time credit. And the parole board didn't adjust it forward. So there's 23 months. So long explanation. After the discussion on the time, the parole board member had a long explanation about protected speech and the sovereign citizen movement, and asked me if I might be a member of the Sovereign Citizens, which is actually a terrorist group. And that's where he went next.
Are you a sovereign citizen?
No, no. they're whack jobs and homophobes, racist and misogynists. No, I don't agree with anything that they have to say.
Okay. What happened next?
So the next thing they did was ask me about my criminal case.
Okay.
I told them the circumstances of my criminal case, very similar to what I've presented here. Um, and I didn't try to diminish my role in what happened. I try to own, you know, what I'm at fault for. Um, and I have no problem with owning that, but I can't own what I didn't do. Um, so, um, so yeah, I didn't try to diminish what occurred. Somebody died, and that's it was tragic, and it was avoidable and preventable, and it never should have happened.
And what was the parole member's response?
His exact words were, uh, "We don't care about that. You've done more than enough time for that," and he waved it off, like waved in the air. We don't care about that.
He actually said, "We don't care about that."
Yes,
And how did you take that?
I was surprised and shocked, and a little bit hopeful because, I mean, that's what I'm locked up for. And if it's what I'm locked up for and they don't care about it, then that pretty much bodes well, I think, for me getting out of prison, I would think. So I found it odd, and encouraging, sort of.
Did he ask you questions about testimony from the first trial?
He certainly did. He asked me about the testimony of Dr. Belraj, who testified in the first trial that I stabbed Andrew Crouch from behind. And in the second trial, her testimony was just the exact opposite. She testified that I stabbed him from the front after we got our own coroner to impeach what she had said in the first trial. So he was asking me facts from the first trial rather than the second.
Why was that significant?
Well, previously I had read the case summaries that the parole board had presented because Andrea Reno got those in 2011. And the case summaries all say things like Andrew Crouch came to the apartment to pick up his kids, um, and then was stabbed from behind. And that's not what happened. And when you read the Court of Appeals decision, um, they say expressly that Andrew Crouch knew his kids weren't there. He was told that his kids weren't there. And the testimony in the second trial was unanimous across the medical experts that he wasn't stabbed from behind. So, um, yeah, so that's determinative. You know, it, 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 if he stabbed from behind and he came to pick up his kids, I look like a liar. And so I wanted to set the right. That's not what came out in trial. That's not what they said. But they keep relying on the first trial that was vacated rather than the second.
Did you point out that information was from the first trial?
I did.
And how did he respond?
He said, "Okay," and that was it.
What then? Oh,
Excuse
God
me.
bless you.
Um, so they moved on to discuss the disciplinary violations.
What did you say?
So I explained about Trevor Clark and the Prison Rape Elimination Act and how all of the conduct reports were written by Trevor Clark, and it was written as a campaign of PREA retaliation.
Scott Wiedemer, in an affidavit marked as Exhibit C, claims you never brought any false or inaccurate information to the board's attention. Is that true?
Oh, absolutely not. Um, I don't know what hearing he was attending. If, so, first was the months. That was the first discussion I had. I told them that the months were wrong. Second, I told them that they were working from the wrong information from the first trial rather than the second. The third thing was my disciplinary record and that it was PREA retaliation, and that the findings of the RIB and SMP were not involving due process, and that those were not accurate conclusions to draw.
How did the parole board respond when you raised the PREA violation committed by Trevor Clark?
So I heard a woman's voice but didn't see her face. And she asked me if I had access to mental health programs in Virginia. And I told her I couldn't take programs in Virginia because I was from Ohio and those programs didn't count. And she said, and these are her exact words, "Well, I hope you get the hope. I hope you get the help you need," um, which seemed to imply to me that I was nuts, thinking that Trevor Clark had done everything that Trevor Clark had obviously done. Um, then the parole board member on the screen said it sounded like I was deflecting.
Deflecting?
Yes. Uh, yes.
Okay, same word as in their decision?
Yes. So it seems to me that Scott Widmer is saying I didn't bring false information to their attention, but in their own decision, they said I was deflecting when I was refuting the information they were working from, which is the same word they used in the hearing. So I don't know how I could be both deflecting and not bringing false information to their attention.
Did you attempt to explain that there is no due process at the RIB or the SMP?
Yes.
Did you tell them that your SMP decision was vacated
Yes.
and they relied on those anyway?
Yes.
What happened next?
They asked me about my run for governor. On the radio show, there was this whole theatrical thing. I was running for governor of Ohio. Um, so there were postings online, and they were asking me about the information that was posted online. And then they asked whether I had permission to do the radio show.
Permission? From
Right.
who?
That's what I asked him. And he didn't answer.
So after
So I
being
still don't know.
sorry. So after beginning the hearing extolling the right to free speech, he proceeded to interrogate you regarding protected political speech in a public forum.
Yes.
Did he ask you about the 3-bedroom apartment?
No.
Your transportation?
No.
Your clothing already hanging in the closet?
No.
Your employment at the Library of Baseball Stories?
No.
The civics organizations you joined?
No.
Your thousands of hours of community service work?
No.
The programs you completed?
No.
Your educational achievement?
No.
Your recognition by Rosa Parks?
No.
Your books in publication?
No.
Your papers and effects archived at the University of Michigan?
No.
Did they then deliberate?
Yes.
And he gave you a 5-year continuance?
Yes.
How did he explain the reasoning behind the continuance?
Well, they talked about the constellation of disciplinary findings, which we've already discussed how the whole process was weaponized by Trevor Clark as pre-retaliation. That's the very first thing that he spoke about. Um, he also said that because I was transported to Virginia, I must be a danger, and they can't pretend that that didn't happen since I was so dangerous as to get transported to Virginia. And now it turns out that they didn't even follow any legal process to get me there. They just illegally renditioned me there, which wasn't the assumption of the parole board at the time. Um, they also told me that my run for governor constituted a threat to the life of the governor, and they took that very seriously. Um, they said that there was public opposition to my release, but didn't tell me who. And they told me my security was too high.
Can you explain threaten the life of the governor?
Not really, but I'll try to explain. So, um, yeah, nobody has has ever accused me of threatening the life of the governor until I got to the parole board. So I wasn't charged. I wasn't given a hearing. They simply sua sponte decided that running for governor constitutes a threat to the life of the sitting governor, and found me guilty on the spot. Didn't give me a chance to defend against it, and gave me 5 years in prison for threatening the life of the governor when I never did that.
Were you criminally charged with threatening the life of the governor?
No.
You said the parole member told you that your security was too high.
Mhm.
What was the security level at Buckingham Correctional?
Medium security, which is as low as I can go. I can't be housed any lower than medium because I have a life sentence. I can't be housed at a minimum security prison. So there is no way for me to get to a lower security prison than medium.
Why did he think your security was too high?
Well, because he didn't know that Virginia's number system doesn't correspond to Ohio's number system. In Ohio, level 4 security is maximum security. In Virginia, it's not, because they have road camps are level 1, and then they have various levels of minimum. And so level 4, I was at a medium security prison.
He told you there was public opposition.
Yes.
Did they tell you who?
No.
So the parole board extended your imprisonment for 5 years based on disciplinary PREA retaliation where there was no due process
Yes.
and an erroneous understanding of your security level
Yes.
and an erroneous understanding of your illegal rendition to Virginia
Yes.
and an irrational interpretation of protected political speech as threats without you ever being charged
Yes.
and public opposition without revealing who that was.
Yes.
And how did you respond?
I told them to save the footage of the hearing for future litigation.
To your knowledge, has the parole board turned over that footage?
No.
Do they have the footage?
They say they do not.
Scott Widmer, in his affidavit, said that you never requested reconsideration by the parole board. Is that true?
No.
Did you request reconsideration
I did.
prior to filing this action?
Yes.
Did you receive an answer?
No.
Did you inform the parole board of your correction to your time calculation that moves your parole hearing forward by 23 months?
I did.
Did you receive an answer?
No.
On October 30th, 2023, did you send a second copy of your reconsideration request and your notification of your sentence recalculation by the Bureau of Sentence Computation to the Ohio Adult Parole Authority?
I did.
Did you receive an answer?
No.
Is the receipt of that certified mail included in Exhibit 48?
Yes.
So when Scott Widmer claims in his affidavit that you never brought false information to the attention of the parole board and that you never requested reconsideration.
Yeah. Big fat lie. Well, no. I'm not supposed to say big fat lie. I was told not to use that phrase and that I should say that it is a material misrepresentation of the facts. So it isn't a big fat lie. It's a big fat material misrepresentation of the facts.
Okay. That is all of our questioning.
Mhm.
Thank you for everything that you have done.
Thank you.